May I please, Your Lordship?
Yes.
May I please to mention item number 6 and 7, Your Lordship? Your Lordship, here the PhD department has been implemented, Your Lordship, and I need to receive instruction on that, Your Lordship.
Short time may be given, Lordship.
Your Lordship, instruction has not come, Your Lordship. That
The
is
only instruction required is whether your agreement is admitted or
Yes,
not.
Your Lordship,
Huh?
that is
Now
important.
what is then? How you can just phone them up? Should we ask them to bring the record?
Your Lordship, I have to bring the record.
Huh? To bring the record. So you bring the record, that will decide the issue. I think there's nothing. No affidavit is required. Right. Miss Livika Leonard, counsel for the state respondents, submits that she has not received instructions to stop. As the issue to be decided is as to whether the state government has accepted the agreement executed between the petitioners and between the petitioner's village or petitioner's clan, petitioner's clan and the government, Miss Livika shall produce the records and obtain instructions with regard to the same by the next date. This is the matter after the vacation. Or when?
Your Lordship, that is my prayer.
After a week.
After a week. This is the matter after a week.
Your Lordship, I also beg to mention item number 10, Your Lordship.
Yes.
Here also, Your Lordship, I need to receive instruction, Your Lordship. So after vacation, Your Lordship.
30 years.
Yes, Your
completed,
Lordship.
huh?
Your
Then
Lordship,
what is
but
there?
however, Your Lordship, at least Your Lordship, an instruction has to come for Your Lordship. Because on my part, I cannot just randomly.
Okay, Miss
Prestige.
Livika Leonard GA
Yes, Your Lordship.
submit that she has not received instructions with regard to whether the petitioner has completed 30 years of service and has been receiving regular pay scale. That's all. That's the only issue.
Yes, Your Lordship. However, let an instruction come, Your Lordship. That is my humble prayer, Your Lordship. After vacation, Your Lordship. I'll file an affidavit.
Why affidavit? Your verbal submission will be good enough for this court.
To the convenience of the court. If an affidavit is
Well,
required.
you can just call them up and it can be done. I think this thing. Wasting time otherwise. Yes, what to do, Mr. Mohan?
Lordship, it can be listed anytime within 2 days, Lordship.
Your
2 or
Lordship.
3 days,
Your
Lordship.
Lordship, my
If
Lordship
instruction
knows
can
the
be-
condition of our working system of our.
In that
here
case,
in
next
Nagaland,
week,
Your
Lordship,
Lordship.
not next week.
Lordship, it will not be possible, maybe, Your Lordship. You can give an endeavor, but.
She's probably because of Hornbill and Christmas season and all. So this is a matter on give a date.
Like after vacation, Your Lordship.
This is the matter after vacation.
Your Lordship, similar pay with 15 also. It-
All
it
these
is-
actually I can
Yes, with
dispose
30
of.
years, Your Lordship.
Huh? I can dispose of.
Yes, Your Lordship.
Otherwise, what can be done also? That again, you all will not do it unless we can say that if he has, you just verify whether he has got this, and then if he has got it, you which would show the copy of the driving license submitted by the respondent number 6 to the state respondent. He is praised that the matter may be listed next week. Next para, you right? So the notice was issued to the respondent number 6 by a registered post with AD on
1/11/2023.
no 3/11/23. As per you submitted your Talabana maybe on 1/11.
Yes, Lordship.
The notice was issued from here
Yes, Lordship.
on 3/11/23. Full stop. However, there is no return of AD card or unserved notice till date. Await service report on respondent number 6. List this matter in the next week. On which date? Mr. N. Angami shall produce the records.
Now, Your Lordship, the interim order passed earlier. may be
Interim order
continued.
passed earlier shall continue till disposal of this case.
Obliged.
Lordship, I also beg to mention item number 19 on behalf of my colleague S. Mere, Lordship.
Item
19, my lord. I'm told that your lordship, she is here to receive instruction in this matter. Because of bereavement, your lordship, she could not make it to the court today.
when can she make it?
Your lordship, because your lordship, item number 24 also, she is the leading counsel for the state respondent even in this matter. Now she has requested item number 4 to be listed on Thursday. Your lordship.
24.
24, because she is the leading counsel even in this matter.
Okay, that's no problem.
Lordship.
But 19, he's not getting his salary from January.
Lordship. Yes.
Christmas time. Imagine if you did not get your fees.
Correct.
How will you enjoy Christmas?
Correct, madam.
Then this has to be taken up. She needs to get instructions.
Lordship, if 2 weeks time can be granted.
No,
your
no,
lordship.
no.
Or at least a week time, your lordship, then.
Well, what about this week? Next week, everybody is in holiday mood. He needs the money.
Lordship, I'm just a peon. And moreover.
He needs the money.
some-
That's all. It's not. You see, you have got to think of some things humanitarian.
Correct. Lordship, since I'm not in this matter, this.
That's what. Is she coming this week?
Yes, your lordship, she told me that.
Oh, she's coming on Thursday, right?
Yes.
We'll list it on Thursday.
Lordship.
Lordship.
Right, on the prayer made on behalf of Ms. S. Mere,
Lordship.
Learned Counsel for the State Respondents, list the matter on Thursday. Item 19 and item 24.
24, madam. 24. Lordship, if I may be allowed to make one,
Obliged.
item number 18, your lordship.
Ah.
In this matter, I have received the necessary instruction. If a short time can be granted to me, your lordship.
Mr. N. Angami,
Lordship.
Learned Counsel for the State Respondents submits that he has received parawise comments and will be filing affidavit within
2 weeks time, my lord.
2 weeks. List the matter after the petition.
I am deeply obliged, my lord.
May I please, your lordship, I beg to mention item 17. We have received the affidavit in the position filed by the state. So 3 weeks time may be given to file a reply.
Miss,
Kate Sucre.
the regularization,
Yes, lordship.
the name is not here.
It is Kate Sucre. It's there.
Yeah, okay, K. Sikri. K. Sikri, Learned Counsel for the petitioner is granted 4 weeks time to file the affidavit in reply. This is the matter after 4 weeks.
Obliged,
Lordship,
my lord.
I also beg to mention item 21. Here we have received instruction to appear for respondent 2 and 3.
Okay,
So some time may be given to us to file affidavit in question.
this is the chieftainship thing.
Yes, lordship.
Miss K. Sukri, Learned Counsel submits that she'll be appearing for the respondents number 2 and
2
3
and 3, yes, lordship.
and needs time to file affidavit in opposition. Have you filed the Fakalatnama?
Yes, we have.
So, sir. Prayers allowed. This is the matter after 4 weeks.
Obliged, Your Lordship.
May I please, Your Lordship?
Yeah,
Lordship, I would
yeah,
like
just
to,
a minute. Madam, you're for the respondent, correct? Who is for the petitioner? Have you told them? You have told them? Okay. Yes,
Lordship, I beg to mention item number 9.
9. Yes,
Lordship, we have filed affidavit in reply.
Ah.
So,
readings are
if-
complete.
yes. Lordship, if this matter can be fixed on Monday or Tuesday.
Lordship, I have some difficulties next week, Lordship. Had it been today, Lordship, the matter could have been done. The short matter.
Lordship, due to unavoidable circumstances, my senior counsel is out of station at the moment.
Now what to do? I don't know. You fix a date.
Lordship, if you can be immediately listed after the vacation, Lordship.
Okay.
If agreeable to the petition, Lordship.
If not agreeable, also what to do?
Yes. Lordship, the matter needs urgent disposal. Because here's a question of recruitment to be done by us, Lordship.
Then why do you want it after vacation?
Lordship, if the council will not be available on Thursday or Friday, Lordship, the matter can be heard.
On our
We
part,
have- huh?
our preference is Monday or Tuesday. If that cannot be,
I don't know. I leave it up to y'all because
Because Lordship,
Thursday we have fixed quite a few already, I think. I can hear, we can attempt, we can keep it Thursday also. I don't mind. I can keep it, but they are not. Yeah, are you ready Thursday?
I was told by my senior on Monday or Tuesday. I'm not sure of Thursday.
So I leave it up to y'all. Y'all decide. Y'all have a standing committee outside, and then y'all can come back and tell me.
uh,
14th.
I don't know. Is it agreeable to you?
Yes.
Okay, right. Mister?
because Monday.
Abel
this
Ayemi.
Huh?
Abel Ayemi.
Abel Ayemi, learned counsel for the petitioners, and Mr.
And Mozoi
N. Mazui,
for respondent 2 and 3, Lordship. The medical department,
correspondence number 2 and 3.
Lordship.
Pray that the matter may be listed on 14, 12. List the matter on 14, 12.
Lordship, my name may be reflected for respondent number 2 and 3.
Registry to reflect the name of Mr. N. Mazui
Lordship, there is a interim.
for respondence number 2 and 3.
2 and 3.
Lordship, there is interim passed earlier.
Interim order to continue till the next date.
Lordship. Obliged, Lordship.
Obliging, Lordship.
This Lordship, I beg to mention item number 27
Yes.
on behalf of Mr. Younger Wati,
Hmm.
counsel for the respondent. I plead this matter may be listed next week.
Where is he?
He has some personal difficulties. Your Lordship.
Is he coming this week to court?
No ideas,
No idea.
no idea.
He's not coming this week. Why? He is very irregular. Huh? Regularly irregular. Okay, Miss Item
Item 27.
on the pair. Yes, what to do, madam?
Lordship, I'm for a petitioner on behalf of my senior IMT non-chair.
Any objection
No, Lordship.
on the prayer for adjournment made on behalf of Mr. Younger Water CGC? This is the matter after the vacation. Is it?
Next week.
Oh, this is the matter in the next week.
Lordship.
Obliged.
Yes, Lordship, I beg to mention item number 13. I'm for respondent number 9, Your Lordship. I need some more time to file my counter. So if this matter may be come up after vacation.
Your Lordship, if
You're for the?
I'm for respondent number 6, 7, and 8.
Okay, so what
If
do
your
you?
Lordship may kindly direct the registry to reflect the name of my senior.
Okay.
Hisim Lohim
Okay, just a minute.
for respondent.
Just a minute,
6,
just a
7,
minute, just a minute. So you're the only one who has got to file affidavit in a
Yes, for
position.
respondent number 9, yes.
I'm making a prayer on behalf of Kiangami. He's also here to file counter, Your Lordship. on
Okay.
behalf of the said respondents.
Okay.
So this may be listed.
So,
as
so
two
no
weeks.
affidavits have been filed till date,
Yes,
correct?
sir.
Right, the counsels for the respondents are granted,
3 weeks, Your Lordship.
I'll give you 4 weeks time to file affidavit in opposition. Registry to reflect the name of Mr.
Hisin Lohim.
Spelling, have you given? He doesn't know how to spell that. He will give you some,
HISINLO.
and him,
HIMB.
HIMB. As counsel for the
Respondent number 6, 7, and 8.
respondents number 6 to 8 in the cause list. Huh. Okay, that is item number, what's the item? is it?
13.
13. Okay.
Your Lordship, I also beg to mention item number 2. 2 to 5, they are all analogous, but Your Lordship, for item number 2, I have just received the counter affidavit filed by the state respondents.
What does it say?
Your Lordship, I need to file a reply to that.
Let us see, what does it say? What is the ground?
If I may take Your Lordship to page number 3. The deponent would like further respectfully state that work charge fixed employees cannot be considered as those regular government employees who are appointed against the sanction post. The department has appointed, engaged the work charged fixed employees just for some particular works on exigency for a fixed amount of pay. Their appointment engagement orders were supposed to be terminated after completion of the work. However, they were made to continue their service, whereas the department had not given them any assurance to grant them scale of pay or absorb their services in future. Owing to the nature of appointment, the department doesn't maintain service book for work charged fixed pay employees, which is mandatory for all government servants. Further, the petitioners, knowing fully the nature of the appointment, accepted the appointment orders and its responsibilities as such. Just because the petitioners had served the department for a certain period of years, it doesn't give them any right to claim for scale of pay.
Well, why do you want to find a reply to that? There's nothing, this is a question of law only,
Yes, Your Lordship, but it is necessary for me to reply, my lord.
right? Who's for the government? Yes, madam, how can you deny them? Minimum scale of pay. That is no reason. Have you read the judgments of the Supreme Court? Basically, it says that if they are working, same pay, I mean, the same kind of work, you might not give them the same salary, but you have to give them the minimum scale of pay at least. So should we dispose it of or?
Your Lordship, since all these matters are taken together and in some.
No, one affidavit would be the same for all. It will not change.
Your Lordship, and they're all from different department as well, so one I've already sent for vetting in item number 5, Your Lordship, which is awaited, Your Lordship. So this may all be taken up together, Your Lordship.
Yes, Your Lordship, since it's an anonymous matter.
I thought I'll dispose it of. The law is quite clear.
Yes, Your Lordship.
One affidavit will do. You see, one department cannot take a different stand from another department. They are all part of the same government of Nagaland.
But in item number 5, I've already sent for vetting, which I've, and in item 3 and 4.
Do you get some extra fees for affidavits?
Nothing as such, Your Lordship,
Nothing.
but since I've already sent it for vetting.
In state of Mizoram earlier, the government lawyers used to get, earlier, long time back, they used to get money for submitting affidavits. So if they said we want to submit affidavit, we had to give them time because then otherwise they'll be losing money. Right. In item
Item
2,
I've already-
item 2, you have got the affidavit.
Yes,
correct?
yes, Your Lordship.
Miss R.
R.
Atsula
Atsula Kips.
Kips. What tribe is this?
Yumkyung community, my lord.
R. Atsula Kips, learned counsel for the petitioner. In 131, submits that she has received of affidavit in the position and wants to file a reply affidavit. Praise the Lord. No, don't say praise the Lord. Just say wants to file affidavit. In the position. The state respondents have not filed any affidavit in the other writ
Three and-
petitions.
3 and 4.
In the other writ petitions.
In item 5, I've sent for vetting, and
That
3 and 4, I'm yet to file.
Correct. So you have not sent for
Yes,
vetting doesn't
yes.
mean that you have filed it.
Yes, Your Lordship.
Though the government advocate submits that the affidavit for WPC 184/2022 has been sent for vetting. This is the matter after the vacation to enable the council for the parties to exchange affidavits in the meantime.
Much obliged, my lord.
With this lordship. If I may be allowed to mention item number 23, part 2 hearing, lordship.
Yes,
And for the petitioner, lordship.
yes.
If this matter can be taken up on Thursday, lordship, day after tomorrow.
Yes,
Lordship, I'm for respondent number 1, 2, and 6.
yes.
Lordship, since my senior is also in this first lordship,
Ah.
I have no objection. Lordship.
Okay. This is the matter on Thursday. On the prayer of Mr. Mua Jamil. Item 20. Which is not objected to by the council for the other side.
Nice. Lordship,
Item 23.
may I please, Lordship. Lordship, I beg to mention item number 26, Lordship.
Yes.
Lordship, kindly list this matter after a week, Lordship.
What is your name?
Nisuka Chishi, Lordship.
Huh?
Nisuka Chishi, Lordship.
Nisuka Chishi.
Yes, Lordship.
On the prayer made by Mr. Nisuka Chishi, learned counsel for the petitioner, which is not objected to by Miss
AIME.
AIME. This is the matter in the next week.
Much obliged, Lordship.
Your Lordship, I beg to mention item number 8. On behalf of Sepong Chan, let the matter be adjourned on Friday, Your Lordship. Let the matter come up on Friday. She has some personal difficulties today.
Where is the affidavit of the respondents number 1 to 4? It's not in the records. So you have filed yourself.
Your
Give
Lordship,
me
I'm not in
item
this
eight.
matter.
You are there.
Yes,
That
Lord, I'm for the
overstayed
petitioner.
1 year, 11 months.
Yes,
You are a grade 1, grade 2.
grade 4.
You're grade 4.
Yes,
Yes, but
Davis.
but you said that you are promoted and what not you said? You're not promoted.
promotion was given, but it is equivalent to grade 4 only.
Acha, it's grade 4. Yeah, if it's grade 4, then Rafiq Masi's case is there.
Yes, exactly, Lordship. There is no fraud, there is no misrepresentation on the part of the petitioner, and all along, government, the department has maintained the date of retirement as 21, 31st August 2021.
And in
In the latest-
in the service book.
Incumbency list also, which was,
In the service book.
yes, and in the incumbency list which they have issued in 2019,
Ah.
there also my date of retirement has been shown as 31/8/2021. That is on the basis of 1986.
Who's the council for this?
She is not present today.
Who is she?
Sepong Chan, Your
Sepong La.
Lordship.
Okay, that's right. Acha, wait, you were saying that the date of, what is the date of birth in the service book?
Date of birth in the service book was. It is with regard to the length of service.
Acha, not
Date of
not
appointment.
date of birth. Okay,
Yes.
length of service.
Appointment was, the first appointment was on 6/4/1984.
6/4/1984.
Yes, and the second appointment was 29/8/1986.
Second appointment on
29/8/1986.
86.
This is in the planning machinery,
Just a minute. The first appointment was with regard to which post?
same post typist.
Typist.
Yes,
In which department?
in the backward area development cell Kohima, that is
Backward
under Commissioner's office.
Area Development Cell Kohima. That is in which office?
Commissioner's office.
Commissioner's office. Just commissioner, that's all.
Yes,
Commissioner's office. Then the second appointment was on 29/8/86
yes,
as typist.
yes.
In which office?
Class 3 post of typist. That is in the
Class 3 post. Class 3. That's not class 4 then. It's class 3.
grade. Type is grade 1, grade 2, grade 3, like that.
Ah.
So this is the bottom line.
Okay,
That
so
is-
is that a grade 3 post or a grade 4 post?
Grade 3
It's a grade
post.
3 post. Okay, grade
in
3
the
post.
planning machinery,
Okay,
Nagaland, Kohima.
okay, planning machinery,
Yes, planning machinery.
planning.
Earlier, it was called as
Ma- ma-
planning
ma-
machinery.
Masonry,
Yes.
planning masonry,
Nagaland, Kohima.
that is a department.
Yes.
Planning masonry department,
Planning machinery, Nagaland.
Nagaland department,
Yes.
Nagaland department,
Nagaland, Kohima.
Nagaland Kohima department.
Yes.
So that's under the government of Nagaland. So then when did you retire?
I met you retired on 16 March 2021.
16 March 2021. And you should have actually retired on
Date of retirement was on 11 to 2021
11 to 2021.
with immediate effect.
Then you should have actually retired when?
I should have retired on 31st August 2021.
31st August 2021.
Yes.
Right?
That is on the basis of 1986.
86.
Yes.
But as per 84,
As per 84, I should have been retired 2019.
when? 11 to no, on 6/4. I mean, it'll be 5/4. 5/4/2019. So, after how many years of service are you supposed to retire?
35 years.
35. As per what rule?
As per Nagaland Retirement from Public Employment Act.
Nagaland
Retirement
from
Public Employment Act.
Public
Employment within bracket, Second Amendment Act. Second Amendment will be within bracket.
Second Amendment
Act.
Act will be outside the bracket.
Yes, Lordship. 2019. 2009, sorry.
2009.
This is Second Amendment, 2009. So earlier, Lordship, what happened? A person's length of service was counted only from the regular appointment. But there was a lot of cases in the meantime with regard to the retirement from public employment, which state should be counted, from which state it should be counted. So earlier, the first enactment was in 2001. That was the first amendment. Now, her appointment was prior to the act came into force in 84.
Okay.
And then
And
her,
that act came into force when?
it came into force in 2001.
Okay, 2001.
Yes. Now, she was appointed again in 1986 on regular basis. So the government all along, they have traded the period from the date of regular appointment. But in terms of the act, actually it should be from 1984, the first appointment.
As per which act?
As per the Nagaland Retirement from Public Employment Act
Of 2000?
Second Amendment, 2009.
No, that is as per 2009. Okay.
Yes.
As per the earlier appointment.
Yes.
As per the before amendment, as per regular appointment.
Yes.
So the 1984 appointment was not on a regular, was not a
Yes,
regular
not
appointment.
regular.
What was it? Temporary? What was it?
It was appointed on temporary basis.
Let us see the appointment order.
Yes. It's in the page.
Page 30.
6 April 1984.
Page 30. 30.
1-3,
13. Okay.
Annexure A.
Yes.
We have-
Temporary appointed. Okay. And where is the second appointment order?
That is at page 16. This is the type copy. Yes. Page 16, it is dated 29 August 1986. So this date was taken for retirement. But they have made me retired from 84.
So they want to.
I'm accepting that. I'm accepting that,
That recovery part.
only the recovery part.
Recovery part is quite a bit.
They have filed affidavit, both Accountant General as well as the state. Accountant General has made categorical statement that we will abide by whatever the
State government says.
this court, no. Whatever this honorable court passed, we are
And
ready
what
to
are the
abide
state,
by
what are
that.
the state government say?
And the state government says the recovery is on the basis of the Accountant General's letter, we have tried to recover. Okay, that much.
Anyway, what we'll do is, I'll just write down the facts so that we can dispose it of on that day when the lawyer comes. I will not dispose it. But it seems that he's got a good case. I think that Rafiq Mashi's case is there, and then that Verma's case is there also.
Yes.
So he'll have to come very much prepared to.
In fact, Your Lordship, the law is settled, so no argument is also required.
Yes,
So,
but then But then the council is not here.
and my name may kindly be reflected in the course list, Your Lordship.
No,
because,
you're in this case.
Yes, I'm for the Accountant General. I'm one
you're
of
for
the
the
standing
Accountant
councils.
But the problem is that the government council is not here. That's the problem. So because of that, we'll have to adjourn the matter. When do you want? Friday. Okay, we'll listen, but okay, right.
Friday, Lordship, I have some difficulty, but my
Yes,
junior will be
your
there.
junior will be
Yes.
the judge enough. So we'll record your junior's name
Yes,
then. Okay.
Lordship.
So we'll record his name now. Okay, right. Heard Mr. C.T. Jamil, Leonard Senior Counsel, assisted by Mr.
I am
Chin.
Chin.
What's up? Also heard Mr.
Joshua.
Joshua. Joshua what?
Joshua
Shaki.
Shaki.
Sheki, Leonard Counsel for the Accountant General's Office. A general prayer has been made on behalf of
Sepong Chang.
Sepong Chang, Leonard Counsel for the respondents number,
State respondents.
for state respondents,
1, 2, 3, and 4.
on the ground that she has some personal difficulty. She or he? She has some personal difficulty. So, sir, the petitioner is agreed by the letter dated 16/3/2021, issued by the Additional Development Commissioner, requesting the Principal Accountant General Nagaland, correct,
Yes.
to recover the monthly pay and allowances, to recover the monthly pay allowances for a period of 1 year and 11 months from the petitioner on account of the petitioner overstaying in service. Full stop. The petitioner's case is that there has been no overstay in service on the part of the petitioner, inasmuch as the petitioner's 35 years of service should be counted from 29/8/86, that is the date on which the petitioner was given a regular appointment as
Typist grade 3. Lord.
typist grade 3 in the planning machinery, Nagaland, Kohima, in the scale of pay of rupees 450-805 and plus allowances. First of all, while order dated 29/8/86 issued by the Development Commissioner from a Planning and Coordination Department, Planning Branch, Government of Nagaland. He submits that though the petitioner had been initially appointed as on a temporary basis as a typist class 3 in the office of the Backward Area Development Cell, Kohima, under the Development Commissioner's establishment, comma, the petitioner's service had to be counted for the purpose of superannuation pension from 29/8/86 in terms of the Nagaland Retirement from Public Employment Act,
Lordship, it should be
comma,
6/4/1984.
Huh?
6/4/1984, not 29/8/1986.
Acha, by 6/4/1984. By the Nagaland Retirement from Public Employment Act, comma, that one, before the amendment.
Second amendment.
No, before the second amendment.
1991. I think it is 1991.
1991. You give me the data. Give me the data.
Yes,
huh?
Lordship.
It was only in view of the second amendment to the act which came into force in the year 2009, wide the Nagaland Retirement from Public Employment bracket second amendment bracket to Act, 2009, that the petitioner's service period had been counted with effect from 6/4/1984. He submits that there be no fraud or misrepresentation on the part of the petitioner. And due to the above reason, comma, the state respondents cannot be allowed to recover the excess.
They have recovered
Salary.
about 9,38,784 already recovered. That should be reimbursed.
Recover the excess salary paid to the petitioner for overstay in service, for the alleged overstay in service of 1 year, 11 months. He submits that out of the total amount of rupees, total amount, how much?
Total amount is 15 lakhs.
15, comma,
38, 244.
244.00.
0.00. Out of that,
Comma,
they have
rupees.
adjusted 9,
9,
38, 784.
784.
Stop 00.
00, so I'll give it to you. Has been recovered by the state respondent, which should be returned to the petitioner. Next, Mr. Joshua Sheki, Learned Counsel for the Accountant General's Office, submits that. What is the submission?
Lordship, the law is settled in this regard when the service of the employee is already utilized. My Lord.
Submits that when the service of the government employee has been utilized, the government servant has to be paid for the services rendered.
And it is for the state respondents to act upon the.
Further,
Yes,
it
the
is
request of the
only
employer,
it is only on the request of the state respondents that it is only the state respondents who have to act upon the decision taken by them to recover the excess amount paid due to alleged overstay in service. Before that, you write Mr. C.T. Jamil relies upon the judgment of the apex court in the state of Punjab versus Rafiq Masi, whitewasher, is it? I don't remember. Verse 2015. 2015, no? 2015 says so. And Lalit Verma's case.
2015 for ACC 334.
Okay, like that. Huh? And any other judgment you're relying upon?
Yes, Lordship. Another judgment is 2009, 6 ACC 314.
What is that? Name of the party?
Uh, I have already furnished.
Okay, that 2009 3 SCC is State of Bihar and others versus Pandey Jagdishwar Prasad. Then, right, next para. However, as the respondents number one, as the German prayer has been made on behalf of the respondent number for the state respondents, council for the state respondents, the matter be listed on Friday. Friday, are you sure? Or Thursday? Why not Thursday?
She has some business.
Okay, Friday. So, Friday.
Lordship.
Lordship.
Yes, Your Lordship. Lordship, I'd like to mention item number 11.
We're doing the entire cause list by mentioning it. Yes, item 11, yes, what do you want?
Your Lordship, I'm yet to receive a complete instruction proper.
Okay, Mr.
Mosam Lankamer.
You want the name? How do you spell it?
MOSEM.
That's all.
My lord,
Just a minute. Mosam
Lankamer.
Longkumar. Yes, what?
The matter is simple. If the respondent have no objection, my lord, may kindly dispose. It's a compassionate appointment. I'm checking for a compassionate appointment.
How do we dispose?
If my learned friend have no objection,
Give me that. Item 11. We are doing the entire list by way of mentioning only. We should have done it turn by turn. How do we dispose? By disposing of a representation and giving a speaking order with regard to your position in the seniority list. Correct?
yes, my lord, different vacancy.
Huh?
Because compassionate appointment are not made for 4 years. In the year 2018, 20, 21, and
When did
22.
your father die?
Died on 27 to 2019.
And when did you apply?
On the same year, I applied.
When? When did you apply? Where is your application page?
Yes, the next year, page 22.
So you applied on 17/6.
Yes, ma'am.
Where is your representation?
On page 22, my lord.
Page 22 is your prayer for appointment. After 2019, have you written any letter representation? No.
No, my lord, I filed RTI. And the RTI reply states that 200 plus 218 appointments were made, but no appointment on compassionate ground were made. So I'm agree, my lord.
No. Okay. Okay.
On page 33, I've annexed the RTI reply.
So they have appointed how many persons?
218
To grade 4 or grade 3?
under grade 3 and grade 4. Some grade 3.
And you have applied for what post?
I'm eligible for grade 3 and grade 4, both the posts.
So what you can do is you file a representation to them and we direct that it will be disposed of by a speaking order. Because I'm quite sure they're not going to regularize you just, appoint you straight away. We have to see, because I believe in Nagaland is done by seniority. Correct? If it's done by seniority, unless your turn comes, there is the question of you superseding others. We tell them to take a decision for compassionate appointment within a specified time.
Well, I've already given my representation to the department. So if I give now also, my lord,
Which
unless-
representation? This page 22.
Yes, my lord.
This
Yes,
is
my
an
lord.
application. This is given in 2019,
Yes, my lord.
and then you have just kept quiet. Okay, we'll tell them to decide this. Right. Heard, mister?
Okay, so my lord.
Baghendri Chambo. What tribe are you?
I'm from Ziliang tribe.
Zillian. Okay. Learned counsel for the petitioner. Also heard Mr.
Masam lang.
Mosam Longkumar. Learned government advocate appearing for all the respondents.
Yes, Your Worship.
The petitioner prays for appointment on compassion ground on account of the death of his father. On account of his father dying in harness on 27/2/2019 while serving as a duftry on regular basis in the establishment of the superintending engineer, PhD Kohima Circle number 1, Kohima. Next para. The petitioner's counsel submits that the petitioner submitted an application for compassionate appointment to the respondent number 3, while letter dated 17/6/2019. However, no decision has been taken by the respondent number 3 with regard to the petitioner's representation for compassionate appointment. He submits that besides 18 persons having been given compassionate appointment from the year 2018 till date, in which department?
PhD, my lord.
In the PhD, and 218 regular appointments being made to grade 3 and grade 4 posts during the same period, that is 2018 to 22. The petitioner's case has not been considered. The petitioner's case should have been considered. Well, no, before that, don't say that. You say the petitioner's case, instead of the petitioner's case, you say, the same being in violation of the office memorandum number AR-8/8/78 dated 17/9/2015. The petitioner's case should have been considered for compassionate appointment by the respondent number 3. The petitioner's counsel submits that this petition may be disposed of, the direction to the respondent number 3 to consider the case of the petitioner for regular appointment, for compassionate appointment, and to take a decision on the same within a period of
Lordship, at least 4 months. Lordship. And to consider the case as per the office memorandum.
3 months. I think, a period of 3 months from the date of receipt of a copy of this order.
And Your Lordship, if you can consider the case as per the office memorandum dated.
Next para. No, what have I said? What have I said? No, before that. Full stop. Thereafter, then no, within a specified time period. Full stop. Next fella. Mr. M. Longkumar, the learned counsel for the respondent, submits that he has got no objection to the prayer of the petitioner's counsel. Full stop. However, the respondent number 3 should consider the case of the petitioner, keeping in view the provisions, keeping in view the requirements laid down in the OM dated 17/9/2015. Correct?
Yes, Your Lordship. 2015.
2015. I've heard the counsel for the parties. In view of the fact that the petitioner's application for compassionate appointment, bracket annexure D, has not been considered by the respondent number 3 till date, comma, the respondent number 3 is directed to take a decision on the petitioner's representation dated application dated 17/6/2019 for compassionate appointment in terms of the OM dated 17/9/2015 within a period of 3 months from the date of receipt of a copy of this order, comma, which shall be accompanied with a copy of the writ petition. Okay. Copy of the writ petition also okay. The decision to be taken by the decision to be taken by the respondent number 3 shall be communicated to the petitioner thereafter. Shall be communicated to the petitioner within a further period of 1 month thereafter. The writ petition is accordingly disposed.
For motion from the supplementary course list, item number 35.
May I please, Your Lordship? My lord, the only premises of the petitioner is for non-consideration of the representation that has been submitted to the respondent.
What is your representation regarding?
For application of his ACR.
Okay.
So
Yes.
request ACR. So if a correction is given to the
Correct.
respondent authorities, and it is learned that the TPC is going to be held next year in the month of January. So if the representation is not disposed of, then his junior officer will be promoted.
But as per Devdutt's decision, you're using Devdutt?
Yes, yes.
Okay. So you have given the representation to whom?
To the respondent number 1, to the respondent number 2.
He's higher than the
Yes, madam.
persons who give the.
Yes, madam.
Okay, right. Yes. Any objection?
No, madam.
No, right. Okay, right.
For
Third-
disposal of representation, I have no objection.
Ah,
For disposal of representation, I have no objection. madam.
okay, good. Heard Mr. Imkong Jamil, learned counsel for the petitioner, and Mr.
That and only, madam.
Z.N. Moli, CGC.
Yes, madam.
The issue raised in the petition is very small, in as much as the petitioner has prayed, in as much as the petitioner had submitted representations dated 6/9/2021, 19/12/2022, 6/1/2023, and 27/10/2023 to the respondent, to the
First, I have submitted to the commandant. That is
to the respondents,
Yes.
in view against the adverse remarks recorded in the petitioner's ACR/APAR dated for the year
2019 to 2020,
for the year 2019-2020, and for the year
2021 to 2022.
2021 and 2022. So, the petitioner, next para, the petitioner's counsel submits that till date, the petitioner's representations have not been decided by the respondent authorities. which will prejudice the case of the petitioner in the DPC proceedings to be held
in the month of January.
in the month of January 2024 for promotion to the post of
Subedar Major.
Subedar Major. Next paragraph. The petitioner's counsel submits that the petitioner who is presently serving as
Subedar.
Subedar in the
Within bracket Cyber.
Subedar bracket cipher CIPHER under the Inspector General Assam Rifles North.
Yes.
What have I said? The last sentence. Would be superseded by his junior due to the inaction of the respondents in not taking a decision on the petitioner's application. So he submits that it is the duty of the, no, forget that. So he accordingly prays that a direction be issued to the respondent number.
So there's number 2 and 3.
No, how can it be 2?
2, 3, and 4. 2, 3,
Miss,
4.
who is the accepting authority? ACR.
Commandant.
Commandant, then
Yes.
it will have to be higher than that.
Yes.
The respond number 4.
Yes. 3 and 4.
To the yes, to the direction be issued to the respondents number 3 and 4 to take a decision on the petitioner's representations regarding his prayer to upgrade the gradings given in the petitioner's ACR/APR for the period 2019/2020 and 2021/2022. In terms of the judgment of the Supreme Court in the case of Devdutt versus Union of India and others, reported in 2008, 8 FCC
725.
725. Give me that. Next. Yes, Mr. So-and-so, Learned CGC submits that he has got no objection to the prayer made by the petitioner's counsel. I have heard the learned counsel. No, I have heard the learned counsel for the parties. As can be seen from the petition and the submission made by the petitioner's counsel, the only prayer of the petitioner is for a direction to be issued to the respondents to take a decision on the petitioner's ACR against the adverse remarks given in the petitioner's ACR/APAR for the period dash to dash and dash. Next paragraph. In the case of Devdutt Supra,
My lord, para 16 and 17 is also ready.
Devdutt Supra, the Supreme Court has held that every entry in the ACR of a public servant must be communicated to him within a reasonable period, whether it is a poor, fair, average, good or very good entry. This is because non-communication of an entry may adversely affect the employees in 2 ways. Number 1, had the entry been communicated to him, he would know about the assessment of his work and conduct by his superiors, which would enable him to improve his work in future. Number 2, he would have an opportunity of making a representation against the entry if he feels it is unjustified and pray for its upgradation. Full stop. Hence, not full stop. Para 17. Okay. The Supreme Court further held that non-communication of an entry is arbitrary, as it violates Article 14 of the Constitution. Next para. In para 37 of the judgment in Devdutt Supra, the Supreme Court has held that when an entry is communicated to the officer, the public servant, the public servant should have a right to make a representation against the entry to the authority concerned. And the authority concerned must decide the representation in a fair manner and within a reasonable period. Full stop. It also held that the representation must be decided by an authority higher than the one who gave the entry, otherwise, the likelihood is that the representation will be summarily rejected without adequate representation, as it would be an appeal from Caesar to Caesar. Full stop. All this would be conducive to fairness and transparency in public administration. No, cut that. Full stop. Para 37 of the judgment of the Apex Court in Supreme Court in Devdutt Supra is reproduced below. Okay. Next para. As can be seen from the in the present case, it is not known to this court as to was the entry communicated to you? Or,
Yes, it was communicated.
in the present case, the adverse entry as per the have you written it in your petition?
Yes, yes.
Where have you written para? That it was communicated to you. Huh?
I have enclosed the ACR which they have communicated.
Okay. In the present case, the ACRs for the year 2019, 2020, and 2021, 2022 had been communicated to the petitioner, and accordingly, the petitioner had written the above representations to the various authorities. That is just a minute. That is the representation dated 6/9/2021 had been addressed to the
Commandant.
to the respondent number 5. What about 19/12/2022?
It was also to the commandant.
Then what about 6/1/2023?
To the Director General of.
And 27/10/23?
To the Director General.
Okay, so you write 6/9/2021 and 19/12/2022 had been addressed to the respondent number 5. That is the commandant. The representations dated 6/1/2023 and 27/10/2023 had been addressed to the
Director General.
Director General of Assam Rifles, that is the respondent number 2. However, no decision has been communicated to the petitioner. No communication has been given to the petitioner with regard to whether the petitioner's representation has been decided by the respondent authority. Next paragraph. In view of the law laid down by the Supreme Court in the case of Devdutt Supra, it is incumbent upon the respondents to take a decision on the petitioner's representation for upgradation of his adverse remarks communicated to them by the above representations. However, in terms of para 37 of the judgment of the Apex Court in Devdutt Supra, it would be incumbent. It would be no, 37 of the judgment of Devdutt Supra, the authority to consider the petitioner's representation would have to be authority higher than the one who gave the adverse entry to the petition. So consequently, in view of the reasons stated above, the respondents number 2, 3, and 4 are directed to are to take a decision as to which authority higher than the authority which gave the adverse remark, which gave the grading, which gave the grading in the ACRs of dash and dash, should examine the petitioner's representations dated thereafter. The authority to decide the petitioner's representation should decide the petitioner's representation within petitioner's representation. Full stop. The entire exercise should be concluded within a period of
15 days.
within today's what date?
Right,
Today's what?
fifth.
Within a period of 4 weeks.
Yes.
Within a period of 4 weeks.
Till 31st.
On or before 31/12/2023. But then full stop. Within a period of 3 weeks from the date of receipt of a copy of this order by the respondents number 2, 3, and 4. The petition is accordingly. The decision taken by the authority should be communicated to the petitioner thereafter. The writ petition is accordingly disposed.
For motion, item number 36.
Yes, who's for the state?
Preparing for the state's religion.
So it seems that you have taken a decision. Have you read the case?
Yes, Your Lordship.
So tell me. Now, where is the petitioner's counsel? Miss Kipps was there. Earlier. R. Atsula Kipps. Out here, they were selected for the
Yes,
post
Your
of
Lordship.
teacher.
Hindi teacher, Your Lordship,
Hindi
primary
teacher.
Hindi teacher.
Where is the
And,
advertisement? That
The advertisement is at annexure 1, page 18.
Page 18. Breathing quite heavily.
Oh, Your Lordship. Excuse me, Your Lordship.
I was thinking what's happening.
Your Lordship, the educational qualification is at page 25, Your Lordship.
Page 25.
Item 24, Your Lordship. So since they did not have the requisite education qualification. Your
And what is the case here? They have got. What is their case in the present petition?
In the present petition,
What have they said?
they are saying that.
They think that they don't have.
Your Lordship, they're just banking on one document, Your Lordship, which is at annexure Annexure 19, Your Lordship, which is a letter by the PNR department, Your Lordship. Annexure
19?
19, page 55, Your Lordship. The type copy is at page 56, Your Lordship. However, Your Lordship, the service rule says otherwise, Your Lordship.
Just a minute. Huh? Let us go to page 25, no, you said. HSLC graduate.
They had applied for primary teacher, Your Lordship.
This
so-
is to certify that so and so appeared in the district of Pet, appeared Ratna examiner. So is this correct?
Your
Page
Lordship,
54?
24.
54, 54.
54.
Is this a graduate certificate?
No, Your Lordship, this is only a diploma certificate, Your Lordship. That's why they're.
This is a diploma certificate. How do you
Yes,
say
Your
this is a diploma certificate? Why do you say this is a diploma certificate?
Your Lordship, page 54.
Yes. Which is equivalent to BA Hindi.
Your Lordship, moreover, in a similar case, Your Lordship, with regard to PPC 123/2022, Your Lordship. In that case, Your Lordship,
Yes.
the petitioners had challenged the service rule, Your Lordship,
Okay.
which is with regard to the qualification of the graduate teachers for Hindi and primary teachers, Your Lordship. So
What does the service rules say?
that's
HSLC.
+2, 10 +2, Your Lordship. The service rule says 10
But
+2.
out here, this page 25 says
Yes, Your Lordship.
HSSLC/graduate.
Your Lordship, which,
Page 25.
yes, this is for primary teachers, Your Lordship.
Acha, and therefore what teachers? They have applied for what? Primary
Primary
teachers.
teacher, Your
Then-
Lordship.
So this, come to page 25.
25.
25.
Your Lordship.
Have you got page 25 with you?
Yes, Your Lordship.
Come to the top, item 24.
Your Lordship, their certificate was what? Only 10 plus, Your Lordship. Sorry, 10 matriculate, Your Lordship. They had produced a certificate along with the other diploma certificate. They're only 10. They have only passed 10, Your Lordship.
Class 10.
Class 10, Your Lordship.
They
That's
only
why-
passed class 10.
Yes, Your Lordship.
No, but then, acha, in the application submitted by them, is it?
Yes,
But
yes.
then they have produced this document at page 54. This says that appeared Ratna examination, which is equivalent to BA Hindi.
Your Lordship, with that regard, I have to take instructions, Your Lordship. Instructions, Your Lordship.
Right. No one appears for the petition on top. You obtain instruction. No one appears for the petition on top. List the matter in the next week. Oh, sorry.
For admission, item number 1.
Yes. What is the case?
The Lordship, the case of the petitioner is that he's aggrieved because he's not compensated for his land, Lordship. Now, his land is an agricultural land. Now, the road is already constructed
Over his land.
Yes, already his land is affected and the road is functional. The construction is over. But till date, Lordship, the petitioner has not been compensated. So he's before this court seeking indulgence of this honorable court, Lordship. The, his two plot of land is affected. He's from Nachama village, falling under Kohima district, Lordship.
Where have you said that the road has been constructed over his land?
Lordship, the fact starts from page number 7, Lordship.
Yes.
So here I have given the description also, Lordship.
You should clearly say that land has been, that road has been constructed on the petitioner's land. You did not say that. You just said that illegally taken possession. You have not said that a road was constructed over their land.
Lordship,
And then-
yes, illegally taken possession because it's under the possession. It's a public road now, Lordship.
Okay,
So it's under possession.
No. You see, possession is different. Possession, correct, that's possession, but
Lordship.
you should have clarified that road was constructed, because when you look at the bottom part, you said that he was not compensated for his land nor for the damaged property. So you are saying damaged property. Don't say damaged property. You say acquired property, or take, because it has been taken away and has been used for something else.
Yes,
When
sir.
you say damage, it's like someone has damaged your land and not paid you for the damage cost. It's like, say, somebody throws a stone at your car. It damages your car but has not paid for the damage. But you have to be very clear in your pleadings. I was under the impression that damage was caused to your land, but they have not, like, supposing they build a road on somebody else's land, but then they throw the earth filling in your land, damaging your land. So I thought that was the case. Okay, leaving that aside, there is another thing. When you go to the affidavit of the government, I think somewhere the DC had said that they don't, there's no record of your land.
Lordship, yes, there is no record.
Right.
There is no record. There will not be record because his land is never assessed, Lordship, despite his request, Lordship. So, Lordship, similarly in other cases, affected landowners from his village, Lordship, has already approached this honorable court. Now, this court said that since in those cases, since the construction is over, it's been a span of years have passed. So this court has directed that
Verification.
yeah, no, Lordship, and rough estimate may be made and be roughly estimated. Then accordingly, the compensation be given. Lordship, I have enclosed that in my petition, Lordship. It's in there are two orders. The aggrieved landowner in other cases has approached this court twice, Lordship.
Let us see.
From page number 28, Lordship, this is the first order passed in their case. Page number 28 and 29. Lordship, this is the first order that was passed in the case of the other land owners whose land were affected. So in this case, Lordship, this court has directed that a spot verification be done, Lordship. And so that was done, and still those petitioners were not compensated. So they approached this court again, Lordship. And that is, the order is in page number 31, Lordship.
Yes.
So here, Lordship, if you see the direction portion, Lordship, which is in page number 37, Lordship. Paragraph 16. Lordship, if you would kindly allow me to read
Yes.
paragraph 16, page number 37.
Yes.
However, this court does not have to go further into the aspect for the reason that in terms of the order passed by this court in the petition C142K 2016, which I have already pointed out, A joint verification was already been undertaken, which found that the petitioner's land was affected, which also found that no compensation has been paid to the petitioner. The only hurdle coming on the way of payment of compensation is for the reason reflected in para 3 of the state report dated 30/03/2017, which states that since assessment is to be made in respect of the damage caused 4 years earlier, it would not be practical/feasible to make any realistic assessment now of the damage caused. This court is of the view that the difficulty can be overcome if the state government makes a reasonable assessment on the
yes,
basis.
Yes, who is appearing?
Your Lordship, I bring on behalf of the state respondent.
Yes.
The respondent number 3 and 4.
Yes.
Your Lordship, this project is pertain to the 2010 and 11. It's already completed.
Sure.
And in my affidavit, we have clearly stated how those landowners were identified and how the authority come to forward and pay the compensation to the respective landowner. It is we have already explained in para 8 of our affidavit in opposition. Para 8. Your Lordship, here, as and when development is earmarked by the authority, then when it comes to the village, then deputy commissioner or government, without the assistance of the village council, we cannot do anything. So this landowner, bona fide landowner, is identified by the village council. And based on that, we have to start our process for the acquisition or for the spot verification, assessment of the land, that's all. So here, Your Lordship, here, it is pertaining to the BRT, Porter Road. So as a when a particular portion of land is going to be acquired for the purpose of development. So it is done in the presence of both the border security and then authority concerned and the village council. So in this particular matter, Your Lordship, here, we did not receive any verification or recommendation report from the.
Did you issue any notice? Did you issue any public notice?
No,
that land is going to be acquired?
No, Your Lordship, here, this particular matter, it is done basically with the landowner and the BRTF.
No, but how do you know all the landowners are present? Some person can be having land in America and be living here in Kohima.
Yes.
And similarly, some landowner can be having land in Kohima and living in America.
Yeah.
How will he know? How will the person in America know that land is going to be acquired?
Your Lordship, here, I am totally helpless in one way. Unless the concerned village council keep me information, fitting information, and on receiving the information from the concerned village council, I have to start the process.
That is why.
That is a process.
No, Mr. Council, please listen. That is why the law requires that notice has to be issued, public notice.
Yes.
Have you ever issued a public notice? That land, you see, it has to be issued in newspapers.
Yes.
It has to be, so that, because now, so that to save the government from saying that, so that the government can say, we issued notice, no one came, now they cannot claim. But if you have not issued any public notice, then how are they to know?
No, that Your Lordship, actually, initially, TPR was prepared by the BRTF, and only in the belay basis we were informed, and on the basis of the information.
DPR means?
Yeah, regarding this road.
DPR made by the BRTF.
Yes.
BRTF is not the authority. Yes. No instruction, no, it's too late. That's only delaying. No. Why? Why? You see what we can do. Why don't we send it to the deputy commissioner? Let him make a verification after talking to the adjacent landowners and the other landowners whether they really have land. If they have land, let him take a decision, because we cannot decide whether they have got land. So that the deputy commissioner take a decision whether there is land. If he finds there is land, then let the spot verification be done. And during that decision, deciding whether she has got land or not, You can participate in the proceedings. Why keep it before this writ court? We cannot decide this matter. This is the problem in Nagaland is that you see that there's no land documents. Everything is by word of mouth. That is the problem. Huh? Was paid. Then 2020 of COVID, everyone had to stay home. So what? So what? 19, so what? So there's no, but when was the project completed? You see, with in regard to, no, one thing, Mr. Medi, one thing. In Nagaland, with regard to land holdings, there won't be any record with the DC. These are all tribal land holdings. So where is the question of DC's office having a record? So that will have to be decided by the DC after calling the village council. Then let him decide after calling the village council and the neighboring landholders. Okay, out here, they were identified by the concerned village council. But it might, some persons might be left out by mistake also. How do
Lordship, if I may be able to rebut that, Lordship, it's in my affidavit. Reply to the state respondents, Lordship. Here, there are two statements issued by the two village councils, Lordship, of the petitioner's village. One was the former village council during whose time the road construction was taken place, Lordship. It's in page number 7. Lordship, it says to whom it may concern. This is to inform your kind authority that the ongoing project Botsa Jesu New Ralan Bokajan 2-lane road under project 1890 CC/15 BRTF /project Sewak is undertaken for a decade. But during the course of project, the Nachama Village Council was not informed or directed to furnish the list of affected landowners during my tenure as VCC. And without the consent of landowners, the department BRTF had taken the land. Therefore, some landowners of Nachama village had filed a complaint in court and they were already compensated as per the law of the land. Whereas Sri Rokovole Zumu, which is the petitioner, landowner of Nachama village, case in the court has not granted compensation till date. I therefore appeal the government BRTF to look into the matter as a genuine and grant compensation at the earliest. This is the statement of the former village council chairman. And there is also Lordship. There is also another statement issued by the present chairman, Lordship.
Next page.
Next page, Lordship.
Okay, I've seen. Okay.
Yes.
Yes. What is this? Case? Yes.
Understand, but this thing is happening when this people.
This is not like Assam or.
I'm not that. Our this anxiety is only the proper person should get the compensation. But this is the anxiety.
I know.
Because the public revenue this gathered, so this
Look, in Mizoram, so you know that the documents are there. Whether it's fabricated or not, that's a different issue. But here, Out here, there is no land document.
Lordship may have directed district collector.
To verify,
Lordship, yes, there's no difference.
let the deputy commissioner verify
Lordship.
after hearing all the parties. And then if he finds that, yes, they are the landowners, then he can go for compensation. And of course, you can always challenge the decision at any time. But I don't know, that would not help, I think, because there are no land documents in Nagaland. I don't think anyone has land documents except for a few persons here and there.
Especially in
village.
Dimapur. No, in Dimapur, we have three Moses. They're all declared severe area. So
What area? What area?
But Dimapur, only Dimapur, we have three Moza, Moza 1, 2, 3.
Okay, okay.
That is declared
Where
as
the
cadastral.
okay, cadastral survey.
And the trees are owned by the individual then.
No document, no land document.
No.
So whoever's big and tough, he was 6'8" guy, then he'll say this is my land.
Yes.
And if you are a 5 foot person, you say, okay, take it.
No. As a when the dispute arises in Nagaland regarding the immobile property, it involves all those traditional songs, story, everything is there in the land dispute. And that's why we call it a very unique state.
So should we send it to the DC?
You know, here, one issue is here. Now the project is pertaining to the 2010-11. As a when the project was undertaken, there was another council chairman. And my affidavit was replied by the petitioner. Now the person, council chairman is a new person. And again, if the land of the petitioner was covered or if it was overlooked, then there is a substantial question of fact involved. So this has to be decided on the other forum instead of sending direction to the deputy commissioner on that. Because substantial question of fact, that will decide the fate of the petitioner's claim. So
that is one. There is another alternative.
Yes. So Lordship,
that is another alternative.
Yes.
We can. Should we say? Why don't you go to the civil court?
Lordship, there's a question of violation of fundamental rights of the petitioner is concerned. Lordship, this case, if this court has not entertained other cases, similarly situated cases, then Lordship, his case can be referred. But when other petitioners, aggrieved landowners were affected, already got relief. Even in similar cases, Lordship.
And those cases.
Yes.
And in those cases where this thing was directed to be done.
Lordship, in fact, this court.
That was with regard to the same project.
Yes, even the same project. Lordship, in fact, there were 2 cases, 4 petitioners involved, which were made analogous with this case. But the thing is that, Lordship, those cases were disposed of because those petitioners already got relief.
And those cases were disposed of when?
Lordship, this year only, Lordship.
All this 142 and 177. Yes,
Lordship, these are the final order.
Forward.
In fact, Lordship, series of direction were given by this court, Lordship, to ensure that compensation is received by the petitioners, Lordship.
One at a time. One at a time.
Those directions were not recorded, Lordship. This was a compliance, Lordship. After receiving the compensation.
Compensation. No, this is different. This is compensation. This is what?
These were the 2 cases which were made analogous with this case, Lordship. Now, this is an intimation to the court that they have received after a series of direction from this court.
No, in this case, what was the facts?
The facts were that, Lordship, similar facts only. Similar stretch of land that those were affected. And Lordship, that's why.
But so they were not, but they were in the list of beneficiaries.
They were not in the list, Lordship. They were not in the list. It was only because through the intervention of this court, when they approached this court twice, which I have already reflected, I have already pointed out, Lordship. Based on those 2 orders of this court.
Okay, those 2 orders.
Yes, those 2 orders, based on these 2 orders of this court, Lordship, if you see page number 39, this is the estimate made by the Deputy Commissioner, Lordship. Based on this is the outcome of the orders of this court, Lordship. If you see page number 29, this is a communication given by the Deputy Commissioner, Lordship.
No, you see, madam, one thing in the judgment that you have given,
Lordship.
the question with regard to ownership of land was not in doubt. It was only with regard to whether damage was caused or not.
That is also their Lordship. But the thing is, their names were not given in the lease, which I have finished in the RTI, Lordship. So
In-
Lordship, accordingly,
in
when
your-
they approached this court directed that on the first instance, let the spot verification may be conducted. And then,
No, because that was a different, out there the dispute was with regard to whether damage was caused or not. Out there the dispute is with regard to whether they are the owner of the land.
Lordship, that's why what is the difficulty for the Deputy Commissioner to go and verify and make assessment,
Okay,
Lordship?
how does
That's
it
what the law
matter?
says, Lordship.
No, law doesn't say that. Law says that actually for a land declaration of title, actually now you can go to the civil court. Anyway, yes. No, so what you see. I know. Okay, yes. I understand. No, I understand. No, so whatever. What we can say is that, you see, you go to the deputy, we can say go to the deputy commissioner. If you are not happy with the deputy commissioner's decision, either of you all can go to the civil court. How does it matter?
Lordship, yes. Kindly allow me to make a small clarification, Lordship. The dispute of facts does not arrive here because they have never done the verification. Once they've done the verification, they found that there's no land,
No, madam,
then the
there-
dispute
there-
of facts will come,
there-
Lordship.
there-
What's the question?
Madam, there's other things. There's other things. When did you first have any information with regard to the project? When did you get to know that your land had been affected?
Lordship, once my land was taken, Lordship,
When-
I have been
when?
going to the Deputy Commissioner's office requesting, Lordship.
Since when?
Since 2015, Lordship, I have been verbally requesting the Deputy Commissioner to compensate, Lordship.
So there is a question of delay also. Anyway, so I think we'll let it go to the deputy commissioner's office.
Your Lordship, here, the analogous matter which was pointed out by the
Yes.
petitioner,
Yeah.
they're basing on the report and basing on the ownership report submitted to the deputy commissioner. Because the deputy commissioner is only a felicitating agency. So as and when we receive the lease of the landowner, whose land were affected by the development. So we go to the spot and verify in the presence of the petitioners, police council, and the PRDF.
Yes.
So here, in other case, those leads we have received, now we have verified. And in the present case.
You have refiled?
We refiled the land. We refiled the land and we assess.
Where is the
Then
proof?
payment is made by the center. But here, your Lordship, here, in this present case, why we did not verify the land of the petitioner?
You did not
Why?
identify, you mean? What is
Why? The name of the landowner was not submitted to us. I'm totally ignorant. Unless it is his name is submitted to us, we cannot. And now, your Lordship, here, if it is directed to the deputy commissioner, now it is palliative stage. How to? It has to be come to the light only through evidence now, because it is purchased between 2010, 11. Now, how can I cannot do anything in the spot because time is already gone. But if the petitioner feels that he has a genuine case, let him go to the appropriate forum because it involves the claim of the petitioner has to be proved by way of evidence only.
Lordship.
Now, by directing to the deputy commissioner, you just imagine, Lordship. Project is already done. Even the road might have already got damaged now. Because
No, that's a different thing.
yeah, but different thing. But now at this stage, how can we identify the land? And in the project, there are so many landowners involved. Those landowners whose name were submitted to our deputy commissioner, the BRDF, they have paid the money. But why not petitioner? His name was not there. So we did not verify.
So what is
that's
the
the only
difficulty,
case.
Lordship? What is the
And if the
difficulty
villager
for them
feel
to
that-
go and verify, Lordship? To at least go and verify and get the facts, Lordship?
No, the first thing has to be seen is before verification. The first decision is with regard to whether you're the owner of the land.
Lordship, that is why, Lordship. That's why the village council chairmen are there. Whoever needs to be consulted can be
Yes.
consulted, Lordship.
I don't know.
In the presence of the deputy
His
commissioner,
ownership,
Lordship.
Involvement of the petitioner land has to be proved by way of evidence now, only by the influx of time. So.
No,
that
it's
is
not
ordinary
efflux
request
of
to
time,
Lordship,
Mr. Council. You cannot be so adamant. You see, there are a lot of poor villages all over the northeast
Yes.
whose lands have been occupied by the security forces. Even after 20, 30 years, we direct that there should be verification. You please do not think that everyone is as smart as you. There are a lot of poor, ignorant villagers who don't have any idea of what to do, and then they come to the court very late. I think we should have a little bit of sympathy.
They're exactly the same, Lordship. Except that, Lordship. Lordship, please. Lordship, the only difference in those cases.
There is one problem, madam. You see, in those cases, there was no dispute with regard to title.
Lordship, because those petitioners were, they sought only damage compensation, though their land were affected, Lordship.
No, what I'm saying is, no one disputed their title.
Yes.
No one said that it is not their land. In your case, the question is whether it is your land. That has to be
Yes,
proved.
because Lordship, they have approached this court. The remaining petitioners, four petitions approached this court only after the estimate was prepared by the deputy commissioner, Lordship. Only after the assessment is done by the deputy commissioner, after the direction from this honorable court. In those other cases, Lordship.
No, you please read that. Just please read the order passed by this court. You see, the case of the petitioners is that their lands were damaged. There is nothing here with regard to dispute with regard to title.
No.
If there was no dispute with regard to title, very easily we can direct them to make a verification to see whether there was any damage, and if damage was caused, then you should be paid compensation. Here, we don't even know if you're the landowner. That has to be
Lordship,
proved.
that's why verification is necessary, Lordship.
No, it's not verification. This ownership of land, whether you are the owner of the land, that has to be proved.
Village council statement is not very clear, Lordship. That their lands were affected, Lordship, and they were not compensated, Lordship.
That is after.
In Nagaland, village council authority are the authority which can declare, even the state respondent is saying, given responsibility on the village council. So that all made declaration that their lands were affected. They were not compensated,
My
Lordship.
part is very limited here, implementing agency.
So you go and prove this case before the civil court. It's very easy to prove. You bring those two persons to the court, prove it, and then that's the end of the matter. Will it take long?
Lordship, it will, because it's again, Lordship, already the petitioners are, suffered a lot because the land that is taken is agricultural land, Lordship.
Madam, if you had suffered a lot, you should have come earlier in point of time. You have come after so many years. You have come in the year 2021.
Lordship, not many has the luxury, Lordship, to afford even the court fee, Lordship. Petitioner here is a poor, pastor of a small church, Lordship. If other cases were not considered, that is one case, Lordship. But when others are getting relief from this court, Lordship.
No, if you
in other similar cases, Lordship, even this court instructed.
If you were in the same position, we would have allowed.
Yes, already.
slightly different position. You're in a slightly different position.
Your Lordship, here, I don't have any right to agitate the ownership title over the land of the petitioner. But the thing is, since I've not received the name of the land of the petitioner, but his land was damaged by the development.
You see, but
So-
one thing,
Yes.
one thing is that with regard to title, again the DC will have to be made a party also.
No.
Naturally.
No, my
because-
submission is,
Ah.
I have nothing to do with that.
Ah.
Because his name was not there in the list.
Ah.
That's why I did not go to the spot.
So let
That's the
him
argument.
go
That's the
down.
only thing. That's the only thing. And now, when I'm totally ignorant about the existence of the land affected by the development, so in that case, his name was not submitted to us
Correct.
by the Council Village Authority. So, well, by what action the petition was deprived? I've committed no wrong with the petition.
No. Who is saying you committed wrong?
Now the petition comes under this infringement of fundamental right, because when I'm totally ignorant about its existence, then how can say that
That is why
that petition was filed on the
that is why
26th?
they come to court to say that I've been overlooked.
Yes.
So that's why they come to court.
Yes, and I have
Lordship,
nothing to do.
you know very well,
Just a
Lordship.
minute,
No,
madam,
no.
just a minute.
Then I have nobody to agitate about the conversation also, because I'm not the one. I'm only in between.
Correct.
Felicitator.
So let the
So,
DC decide.
yes.
I think. No, we're not saying that you have admitted yet. We're just saying that let the DC decide. Ah.
Here is no matter down, they not never from the break matter. They should be taken along with this petition because all are similar. All are similar. Because the facts and everything is different, and there the assessment was made by the DC, and we are also this because of miss out matter. Here this not they're watching this the order and taking this trying to get benefit of this order matter. They are now this.
No. We
So-
see out
so-
here.
So your lordship, if suppose lordship directed that DC, then so my simple prayer, small prayer, this other requisition may not be reflected in the order matter. Because they
Yes. I will not reflect.
Yes, well, that is.
I will not reflect.
Yes.
I'll just say that let him take a decision on the title.
Yes.
And let him take a decision there, so that at least they know, even if their case is rejected, they can go to the civil court and challenge thereafter.
Yes.
At least they'll have one more step to go.
Liberty, well,
Right, heard Miss Nitya Vaza, learned counsel for the petitioner. Also heard Mr. S.K. Medi for respond number 1 and 2. And Mr.
In terms of petitioner AG.
MT Imsong addition AG Nagaland. The petitioner's case in brief is that he is the owner of 2 plots of land located at Zedu and Shivachi of Nachama village. The respondents who constructed? Who constructed the road?
PRTF.
The
What road?
The
Respondent number 1, 2.
The respondent number 2.
Yes.
No, let's just say the respondent number 1 and 2. Respondent number 1 and 2 constructed a road over the land of the petitioners. And in terms of the project undertaken for construction of a two-lane road, Botsa-Zizu-New Roland-Bokajan Road under the project 89 RCC, no. Bokajan Road, Bokajan Road. Under project 89 RCC/15 BRTF/project Siva. First of, however, the petitioner was not given any compensation despite construction of the road over his land and the damage caused to his property. The petitioner's counsel prays that a direction should be issued to the respondents to verify the damage caused to the petitioner's lands and to acquire the land of the petitioners by paying compensation in terms of what law? In terms of the acquisition law followed by the respondents while acquiring the lands of other persons for the said project. Next one. Mr. S.K. Medi, learned CGC, submits that the respondents number 1 and 2 had given compensation to landowners on the basis of the report made by the deputy commissioner. Which deputy commissioner? Deputy commissioner. Kohima.
Yes.
The deputy commissioner Kohima. As the name of the petitioner was not amongst the landholders whose lands were affected.
Affected landowners.
In the report made by the deputy commissioner, no compensation was given was given to the petitioner. Next paragraph. Mr. Imti Imsom.
Yes.
One friend of mine is Imti Younger. Imti Imsom. You're out. Imti is all owls, I think.
Yes.
Mr. Imti Imsom submits that the report of submits that the land of the villagers were acquired on the basis of the report made by the village councils of Nachama village and
Village council of the.
by the village councils, by the concerned village councils. To stop, as the name of the petitioner had not been provided by the concerned village councils, no, the deputy commissioner Kohima did not include the name of the petitioner among the list of landowners whose land was going to be affected by the construction of the two-lane road. He also submits that the road had been constructed in the year 2010. 2010-11. And it would be very difficult now to ascertain as to whether the petitioner was the owner of the land.
affected.
Was the
petitioner land
petitioner was the
affected.
affected owner of the land and whether damage had been caused to the land of the petitioner. Full stop. Next. So what is so what about the submission made that they should go to the deputy commissioner?
Yeah, no, your lordship, my submission is, since it involves substantial
Questions of law.
question of facts, so it has to be referred to the appropriate forum. Because these are the, whether petitioner land was affected by the construction of road or not, it has to be proved by the evidence only.
No, okay. Okay. Next. I have heard the learned counsels for the parties. I just the learned AG also submit that the question of ownership of land has to be decided by the by appropriate forum, as evidence needs to be adduced.
Lordship, with the permission, not the ownership, but affected, whether his land was affected or not.
Okay.
That is why.
So affected, let it be decided. If a road is there, there. How can you throw away a road?
Yes.
You see, you just have to see whether road is there. That's all.
I don't question
You
about
see,
the ownership.
So, Acha, you're not an ownership.
Whether his land was affected by the road.
No, then that you see, because I can understand damage like earth filling around. But if a road is there, then that will always remain.
Yes.
Then if it, no. Anyway, that you see, those things are factual. If it will not be there, it will not be there. That she cannot claim. It will depend upon the verification report made by the DC. That's what they would. That you can always challenge. You see that aspect. If the DC finds that there was tree cutting, then it doesn't leave you helpless. You can always challenge it under Section 12 of the Nagaland that Acquisition Act. You can always challenge it. The report of the DC is not final. You can always challenge it. That even she can challenge it. She can say that the market rate is too less, or the rate is too less, or it is incorrect. Both sides can challenge it. So there's no problem with that. So I'll say that you both agree. Better. Right. Next. Okay. I won't. I've heard the learned causes for the parties. Full stop. The issue here is with regard to whether the additional AG submits that he does not that the issue here is not with regard to whether the issue here is with regard to whether the petitioner is the affected landholder, and the same requires evidence to be taken. Full stop. Next para. I have heard the learned causes for the parties. Full stop. As the issue to be decided in the present case pertains to. No, before that, you're right. I've heard the learned causes for the parties. The affidavit in reply of the petitioner to the affidavit in opposition filed by the respondents number 3 and 4 shows that certificates have been issued by the former village council chairman of Nachama village, KV Meadow Zumbu, on 7/10/23, and by the present chairman of the village council Nachama, Tefulusa Sanchu, that's at page 7 and 8, dated 16/3/2023, stating that the petitioner's land has been totally damaged due to the construction of road, and that the petitioner has not been given compensation. Full stop. Further, there is nothing to show the extent of the damage. Further, there is nothing to show as to whether any damage had been caused to the petitioner's land, as no official records have been maintained by the state respondents. Full stop. As there are disputed questions of fact, with regard to the same, this court is of the view that the Deputy Commissioner, Kohima, should make a verification report with regard to whether the petitioner is the owner of the land. Locate, is the affected owner of the land.
Yes.
Affected owner of the land. uh, Affected owner of the land. Affected owner of the land that is affected by the construction of the two-lane road under Project 89 RCC/15 BRTF/Project C1. Stop. The verification report by the Deputy Commissioner Kohima should be done after. No, should be done. Should be made. By calling for the participation of the BRTF by the respondents number 1 and 2 and the petitioners. Now the petitioners and the village council of the concerned villages. Concerned village. The said exercise, the said verification report should be made within a period of 2 months. 3 months. 3 months.
Yes, December, January is very difficult.
3 months from the date of receipt of a copy of this order. If the Deputy Commissioner comes to a finding that the petitioner is affected landowner due to construction of a road on the land of the petitioner, the Deputy Commissioner Kohima shall make an assessment of the compensation to be paid to the petitioner in terms of the land acquisition law that has been applied for acquiring the adjacent land in terms of the pertaining to the said project within a further period of 2 months. Thereafter the payment, if any, we made should be deposited by the respondents number 1 and 2 before the Deputy Commissioner. First up, okay. Which shall be thereafter disbursed to the petitioner. First up. It is needless to add that if the respondents are aggrieved by the verification report made by the Deputy Commissioner, they are at liberty to make a challenge to the same in an appropriate proceeding before the appropriate forum. So that leaves you both.
Lordship, I have a small request, Lordship. The petitioner's name is reflected, the spelling is wrong in the CIS. Lordship, I may be allowed to correct that, Lordship.
No, then what will have to be done is you'll have to make, then you'll have to file an application. Because you see, now what has happened, not like before. Earlier we used to do it. We allowed. By hand also we allowed. Now, unless you make an application, we allow it. Then your amended cost title will have to be submitted, and thereafter it will have to be uploaded in the CI system. That will take time. We can say out here at the beginning, the petitioner's counsel submits that the petitioner's name has been inadvertently recorded in the where?
CIS, Lordship.
But in the petition it's correct.
Petition, Lordship, in the synopsis and the index, it's correct, Lordship.
Okay, then it's okay. Yes. in the, submits that the petitioner's name has been correctly recorded in the, what is, how should it be spelled?
Lordship, RUOKUOVOLIE.
Oh, but in the cause list it has been.
Yes, Lordship.
Okay, that's
it's-
okay. It's here in the petition. Submits that though the petitioner's name has been correctly recorded in the writ petition, in the cause title to the writ petition as RUOKUOVOLIE, inverted commas, comma, the petitioner's name has been Rokovilla. Rokovilla. Zumbu,
ROKOVO.
No, ZUMVU.
Yes,
ZUMVU, Zumbu, the petitioner's name has incorrectly been recorded in the cause title, in the cause list as ROKOVOLIE, Zumbu. That is because, some parts of the writ petition is correct, some part is wrong.
Lordship, yes. The affidavits are correct, Lordship. Cause title and affidavits.
Okay, in the writ petition, in the affidavit of the writ petition, right? In the cause title and affidavit of the writ petition, it's correct. Yes. I said disposed of, no? I said no. Writ petition is accordingly disposed of.
For admission, item number 12.
May I please lordship? My lord, this matter will be closed basing on the letter dated 28th July 2023. I have already submitted before the earlier occasion, my lord. The case of the petitioner is under consideration, my lord. It is before the cabinet.
I don't know. It's okay with you.
Yes, Lordship, no objection.
But you do it within a specific, within a reasonable time.
Within 2 months, my lord.
Within 2 months.
Yes, ma'am.
Okay, right. Mr.
Itipapong.
Itipapong, learned counsel for the state respondents, submits that the petitioner's case for regularization of his service is under consideration of the government, and a decision will be taken in the near future, within 2 months.
Yes, my lord.
Within 2 months, within 2 months, within 2 months. So, in this regard, he has submitted a letter dated it's letter number CE/PHE/GEN-EST/WC/2013 dated 25/11/2021, issued by the Chief Engineer, Sanitation and WSSO, PhD, Nagaland, Kohima, which states that
The lordship may kindly see the last page. It is before the cabinet, my lord. The last page. Yes.
which shows that letter dated so and its annexures, which shows that. No, do say that, and it's read with, no, letter dated so and letter number PHE-1/ESTT/01/2022 dated 28/7/23, which shows that the petitioner's case has been sent for consideration of the cabinet. He accordingly prays that the writ petition may be closed. Miss
The acknowledges, Your Lordship.
learned counsel for the petitioner submits that she has got no objection to the prayer of the petitioner. To the prayer of the, to the prayer made by the, no, to the proposal made by the counsel for the respondents. In view of the consent of the parties, and keeping in view the fact that the petitioner's prayer for regularization of the service has been sent to the cabinet for its consideration. The writ petition stands closed. It is expected that, it is hoped that the respondents shall complete the process for regularization of the petitioner's case within 2 months from the date of receipt of the copy of this order. The petitions accordingly disposed.
Much obliged.
Is accordingly closed.
May I please, your lordship? Lordship, I beg for your lordship's pardon. With regard for a motion, supplementary motion, item number 36, your lordship.
Yes.
I might have overlooked the costlies. I was actually on my leg in court number 3, your lordship. In this matter, I actually have an interim prayer. So if this matter, maybe I can kindly list it on Thursday, your lordship.
You call the other lawyer. Who was there? Acha. What do you want?
Not to issue appointment order in place of the petitioners, your lordship.
Objection to that, your lordship, because the petitioner does not have a qualification.
Oh, your lordship. As per the, I don't have the briefs with me, your lordship, but I can assist you, my lord.
No, this is not proper. You have to bring the brief.
Then your lordship,
Okay,
kindly on
that
Thursday.
item 36 is with you. Okay, list the matter on Thursday. We pass the order, list the matter again on Thursday.
Much obliged.
We'll see on Thursday.
Deeply obliged, my lord.
For admission, item number 14 linked with item number 37.
Where is the CGC? Mr. S.K. Medi. Yes, madam, what is your case? You are for whom?
For the petitioner in item 37 contempt.
Yes.
But I am not in the writ petition, in the contempt petition, madam.
Then why not
Lordship, in
paying?
item 14, I'm the respondent number 2.
Why are you not paying?
Yes, madam.
Why are you not paying?
Tendency of this writ petition, madam.
No.
Madam, I may be allowed to call him.
You see, okay, you call him.
Yes, madam.
Now we will take up the other matter. The other matter.
For admission, item number 16.
Please, your lordship. Lordship, here the brief facts of the case is that the
Can we dispose it off? Are you
lordship,
all ready?
in fact, lordship, there is an act of criminal contempt in this case.
No,
Yes, sir.
you see,
Madam.
leaving that aside.
Lordship.
There is no point hearing you and not deciding the matter. We are going to waste time.
Lordship.
Can we decide can this case be decided?
If not, as on today, my lord, I wanted to insist upon the Honorable Court with a request to issue notice on contempt. Because the petition has been
Then-
rendered infructuous by the subsequent action after the petition was filed before the Honorable Court, my lord.
Then where is your petition for that?
Lordship.
Where is the petition for contempt?
The lordship, I sought the permission of this Honorable Court, a coordinate bench of this Honorable Court. Now the contempt, it can be issued so motu also, lordship, which my lord is fully aware. When the proceeding is pending before this Honorable Court, another order of removal of the present petitioner as a village council member and also a double removal as a village council chairman was removed, lordship, was issued. So lordship, petition has been made infructuous by the subsequent action, which is an obstruction to the proceeding before the Honorable Court, lordship. I have placed on affidavit.
So it's basically the same issue, that's all.
No, Lordship.
Huh? It's
No,
different
Lordship.
issues, different.
Removal of the petitioner as a village council chairman has been challenged before the Zound Court. Now he has been removed again as a village council member without any cause, without any reason, Lordship.
So you file a separate writ for that. File a separate writ for that.
Lordship, respectfully, my
We
lord.
are not going to jump into your problem.
No, Lordship, if my lord may kindly allow me to make this submission, Lordship.
These are different issues.
No, Lordship, the majesty of the honorable court will be disrespected and the state authorities will act according to their own whims and fancies,
So you file.
making a mockery of the proceedings before the honorable court, my lord.
What to do? We are like that only.
So, Lordship, what about the majesty of the honorable court?
Look, let me tell you, just joking. Anyway, look, the thing is that something has happened. You were earlier removed from the post of chairman.
And that was challenged before the
That was
honorable court
challenged. In the meantime, they have removed you from the post from being a member.
of the
That's
village
the-
council.
from the village council. Was there any stay order earlier?
Correct.
No,
Was
Lordship,
there any stay order earlier?
whether there is any stay or not, I
No.
have some authorities, if my lord may kindly appreciate some authorities.
I'm not going to issue any notice for so motor contempt. If you want to file, if you think there's a contempt, please file a petition. What bars you from filing?
That's why, Lordship, I saw the permission of this coordinate bench of the zone court and I was told to place the same on affidavit. I said, if I may be allowed to file a petition for contempt. Because obstruction of the proceeding before the zone court, Lordship, it amounts to criminal contempt.
I
My
doubt-
lord is aware
I
of
doubt-
that.
No, I doubt there is a contempt.
If I may be allowed to place some authorities, Lordship, for your Lordship's satisfaction.
You can, but I don't know if you'll change my mind.
Your Lordship, the brief that I have written, if my lord may kindly allow me to read. Now, this is 1996, 11 SCC 74, the Balwan Singh case.
Look, we cannot correct a perceived wrong at one stroke. The problem is that the court has procedures to follow. You might find it palpably wrong, but we cannot do it as you wish. You know, with one stroke, chop his head off or something. It cannot be done.
Your Lordship, they have also filed an affidavit, and in their affidavit also, they have clearly admitted that the petition has become infractious. And
Yes.
he is also, the respondent number 4 is also a respondent impleted before the zone court. He is aware of the proceeding before the zone
No,
court.
no, you see, both the writ petitions can go together. You file another writ petition challenging.
Correct, my lord.
The disqualification or removal as a member. It can go together. Why can't it go together?
No, respectfully, Lordship, will this not serve as a precedence for the state respondents to act according to their own whims and fancies?
You see, all orders passed by the government are deemed to be valid orders until and unless they are withdrawn by the, set aside by the. What to do? Otherwise, if it is not deemed to be a valid order, then all orders of the government will be in a state of limbo. You cannot act upon it.
Your Lordship,
That is the law, you know. it very
petition is
well.
filed before the zone court.
Sure.
Petition is pending. So during the pendency of the petition, interfering with the proceeding before the zone court.
No, nothing like that. There's no
interference.
There's no interference. That's a question that's a different thing. If there was if supposing you had said that nobody should be appointed as chairman.
Yes, Lordship.
And there was stay order. Maybe there could have been something.
Yes.
Maybe. There also a maybe. But I'll tell you, a very membership has been taken away. Now, as on date, what is wrong? Your only ground is because your chairmanship is under challenge. The removal as chairman is under challenge. That they cannot do. That is the wrong. That is not correct.
No, Lordship, whether there is any stay in operation or not.
No,
I have some
okay.
authorities
Yes.
where by using one's authority, interfering with the proceeding which is already before
Supposing,
the
let me
zone
give you
court.
an example.
Lordship,
Supposing a teacher
my lord,
in a school,
Lordship.
he has to have the qualification of BA. And he is appointed as a teacher. No, and though he has only is a class 12, he's appointed as a teacher. Okay. And that teacher becomes a principal. Supposing there is an order by the government saying removing him from the post of principal, he challenges that order in the court. And in the meantime, the government finds that he is only a class 12, doesn't have BA. Can't the government remove him from the post of teacher?
That circumstance, respectfully, Lordship, does not apply in my present
So that
circumstance.
is why
Lordship.
we have to see the law here. We have to see what is wrong with what is wrong with the order removing you as a member. You have got to show this court what is the wrong in the order removing you as a member. Unless you show us that, how can we say that the action of the government is wrong, off with his head or something like that?
No, Lordship, since my Lord holds a different view, if not respectfully, Lordship, when the proceeding is already pending, why should another action be taken to,
You see,
render the proceeding infructuous, my Lord?
It's not a question of infructuous. It doesn't become infructuous.
So, Lordship, assuming that.
Sorry, you file a, I don't find anything. You can do whatever you want. And I will do what I think is correct.
Assuming that, Lordship, assuming that the petitioner succeeds in this petition against his removal, Lordship, now he is removed as a village council
So I
member.
will leave this pending. In the meantime, you file a writ petition challenging your removal.
In that case, my Lord. My Lord.
We'll keep this pending.
Lordship.
We'll adjourn the matter on your prayer. You file a writ petition in the meantime, then you will tag both of them, and both of the issues will still be there for you to find.
My Lord, my Lord. In that case, Lordship.
So at one go, you might get double promotion. Member plus.
But respectfully, Lordship, not against this, but my apprehension is that this kind of attitude, if not controlled by the Honorable Court,
I
it will
understand.
become a habit,
I know,
Lordship.
I understand. But then you have got to show this court
Yes, Lordship.
as to why your removal as a member is wrong.
Correct.
You're harping on, your only case is that because there's a case pending with regard to your removal as chairman, they cannot remove me as member. Now, like I
Yes,
gave you,
Lordship.
like I gave you the example of a teacher.
I got your Lordship. I
Now,
got your
they
Lordship.
might be having a good reason. You tell me, why is the reasoning so bad?
In fact, Your Lordship, his removal as chairman itself is without any ground. He was democratically elected just for the sake that he wanted to check corruption
Okay,
of some of the members.
That aspect we can
Yes,
look into.
Lordship.
That aspect we'll look into.
Yes, Lordship.
But you have to show us as to why your removal as a member is bad or illegal. You have not said one word about that.
Your Lordship, obstruction of the making a mockery of the proceeding which is already pending on that ground alone I have. Yes,
You see,
Lordship.
it happens. You see, sometimes sometimes laws are made to circumvent the judgments passed by a court. It happens at times, but then doesn't mean that the courts can do everything at one go. We have got to pass a reasoned order. We have got to understand the nuances of a case. Unless you tell us the facts of the new case that you are trying to set up, we cannot take a decision, an informed decision, I mean.
Your Lordship, some of the authorities that I have, the authorities clearly show that when the proceedings are pending, now obstructing, interfering into the proceeding which is already ongoing, that amounts to criminal contempt. I have some authorities, in fact, 7 authorities, but since my Lord holds the review, I have no issue of filing a fresh writ petition also, but just to show that such precedents will not become a habit for the state respondents to take advantage of the
Let
proceedings.
me ask you,
My Lord.
if you want a contempt, we have got to now issue a contempt notice. We have got to register suo motu contempt, correct?
My Lord.
But now to register suo motu contempt, they will come up with an answer as to why your removal has been made.
Not
We are-
interfering with the present case.
Then so they're going to give reasons. Now basically that suo motu contempt will become a writ petition in a way, and everything will have to be decided in the suo motu contempt. So you at least file a writ petition first. I don't know. I do not know whether the suo motu contempt will help. You have got to inform this court as to what is wrong with the order of removal of as a member.
In fact, Lordship,
You have been here 10 minutes. You have not said a word as to why it is wrong, except for there's a pending case here.
no, Lordship, in my affidavit also, I have made a categorical statement that without any ground, he has been removed.
No,
The decision was taken by
as a member.
the village council's decision was only to remove him as chairman. No decision was taken to remove him as village council member, but he has been removed so that this petition will be rendered infructuous. That is the only.
No notice. Where is the removal order as a member?
In fact, I have filed in my affidavit, Lordship. Then this is an affidavit for an act of contempt under section 2C, Roman 2 and 3 of the Contempt of Courts Act 1971, Lordship, by the respondent number 4.
Nine one F. What does 9(1)F say?
Your Lordship, the 9(1)F says that a state government may remove any members of the village council from his office who has been guilty of misconduct in discharge of his duties or of any disgraceful conduct, and 2/3 of the total members of the village council at the meeting recommend his removal.
So no such step was taken, Lordship.
No, Your Lordship, that has to be decided if at all the petitioner. Yes, Your Lordship.
So we'll have to see now whether
Yes.
2/3 have recommended or.
Yes, correct.
So,
No, Lordship.
yes, why don't you bring out the reasons as to why he has been,
No, Your Lordship, in this present
You
writ
see, you can
petition.
make a challenge here itself, in this writ petition itself. You don't
Yes.
have to make a separate. Yes, show us the records.
No, Your Lordship, in fact, in the present writ petition, the removal of the village council member, there is no whisper of it in the present writ petition.
File a writ petition. File a new petition, right? On the prayer of the council for the petitioner. This is the matter after 2 weeks or 3 weeks, 1 week. Next week.
After vacation,
Next week.
Lordship.
Next week. You can
Next
try your
week,
luck.
Lordship. Lordship.
Next week.
Madam.
You can try your luck.
Obliged, Lordship.
Obliged.
Yes.
For admission, item number 14.
Huh? Why you see, this is this. Look, Mr. You see, this is a case where 2012 order has been passed. 11 years have passed.
I understand.
You have not even paid 1 rupee.
My lord, earlier everything was paid, my lord. What happened, my lord, is I saw only one document, my lord. My lord, it was, my lord, the one on depending upon the one this letter, my lord, it was assessed, my lord. It was not brought at the time we put it on a good court, my lord, record when your lordship was in the past order, my lord, on the division bench, my lord. The page 9 of my additional affidavit. Here it can, my lord, with reference to subject above as directed by your authority, by so and so, July 2011, to assess the land value of Simple so and so block so and so, prevailing market rate area 1.92 areas now under list of Project Sevak. On my query, I am of the view that the present market value of the land of Sevak so and so this much. And my lord, the Nagaland Act, my lord.
Okay, you see, now what we can do is, you also obtain instructions.
Yes, my lord.
We'll set aside all the acquisition award. We'll make a new award as per the 2024. Then the rates will go high.
My lord, only my lord, this one.
Since you don't want to acquire as per the old rate, you're questioning the old rate. We'll set it aside. We'll say that make a new rate as per the existing. Very simple. Dispose everything.
One date may be given. My lord, this immediately after.
Think about that. You see, next time you say, since 2012, you have not been given. So if they want to set aside that award, we allow, let the fresh assessment be made. End of the matter. Let them pay. They'll pay now triple the amount. The rate now will be right up.
My lord, this-
Please tell your client,
I
be
understand, I
fair.
understand. I understand, man. But only then, immediately after vacation, and earlier occasion, my son, his, her senior talk, my lord, is after today's problem, my lord. So after vacation, 19th I'm coming, my lord, this will take definite instruction before.
I will write it down also. Okay.
My lord.
We'll write it down also whether you obtain instructions as to whether new assessment should be made into 2024. As per the market rate prevailing in 2024.
My lord, this our silence, my lord,
Oh,
silence
yeah,
again.
since you're challenging it, we'll allow your challenge. We will allow your challenge. We will set aside the award, but make a fresh
My lord, for
assessment.
time being, my lord, your lordship, my request before the
They
honorable
will-
court. My lord,
no,
I'll
so
take
next
instruction. my lord.
time in the court, you concede to them and say that a fresh assessment be made as per the prevailing market rate as on date.
My lord,
End of the matter.
Yes, this one date might be.
You please ask your client
Yes,
also,
my lord,
if they want that.
Yes, my lord, this only this, my your
Simple.
lordship,
It's
should not
very-
be, may not reflect, may not only one
No,
date.
I'm
may
going to
given.
reflect.
My lord,
This
this
is too much.
small prayer, the lordship may not be reflect, but next time on 19, my lord, I take definite instruction. Only small request, my before.
This is you're playing around with.
No, my
person-
no, my lord. Actually, thing is, my lord, this initially, my lord, this when the award was passed, my lord, this they in wrong forum they approached this after, my lord.
No, Mr. Counselor.
I understand. I understand.
You
everything.
know the case.
Yes, ma'am.
You see, in the division bench judgment
Yes,
that we
ma'am.
have written,
Yes, madam.
the only issue that was set out by you all
Yes, madam.
was that the state government should pay, then we will pay.
No,
That was
no,
the main.
no, my lord, that was not, my lord. Actually, they, initially, the Union of India, they filed a review, my lord, review against the writ petition. That was the wrong, my lord. They should challenge the award, my lord. But after review, my lord, this, they filed appeal before this honorable court. This honorable court, your lordship was there, my lord, they pay directly, my lord. And there's an observation is there, section 12 of the Nagaland Act was not reflected. But again, they filed a writ petition, my lord, challenge the award, my lord. That also, they reflecting the order of this honorable court.
No,
in
it's
this section.
okay. So basically, you don't agree to the award given to you, correct? You don't agree to it.
My lord, this rate, my lord, at the
So
time it was
yes,
high,
at the
my
rate.
lord. And
So we will say we will set aside the award as per the prayer of thing, which is agreed by the respondent, and a new assessment be made as per the prevailing market rate as on today.
that
Simple.
For that, my
So
lord,
you talk to your client and you do it, and you take the decision, and you come and you concede to their prayer, and let a new assessment be made as per the prevailing market rate as on date, because you have got no money as per the old rate. Because now it's no point having the rate which was made in 2010-11, no point.
yes,
Doesn't
my lord.
So let them.
Mizoram
so-
also, this act was said by your lordship.
Ah.
So was set aside, my lord.
No,
I've gone to-
because they are losing their land also.
Yes, my lord. And same time, my lord, what happened, my lord, in other cases, I am this the actual landowner, my lord, this is a problem in every in Assam also, my lord. Nowadays, some people are coming, well, some they are taken up and file it. This is happening, my lord. So these are another problem. This misuse of money of the government of India as well as the state, all states. Right? This aspect has to be also looked into, because this is our money, my lord.
But what to do?
Yes, my lord.
These
That
are
is-
your officers who agree to it.
Yes, my lord.
Now, they are the ones, you see, this rate had come about by way of a consensus.
No, man, not
It was a-
consensus,
no,
not
no.
consensus, my lord. So that was, my lord, not got out because honorable court, my lord. This is the problem. My lord, earlier, all litigation, my lord, filed by Union of India, the properly not placed before this honorable court, my lord. If properly brought before the honorable court, that the orders, so far I understand, my lord, so maybe different, it had been defined, my lord. So all this thing was not approached in proper form. Everything was done, my lord. So I'll just request, my lord, only one date might be given, my lord, immediately after vacation. I'll take definite instruction, as your lordship says, the new act also, that I will discuss everything, and only no order is required to reflect to them. This is my very simple prayer before.
No, I'll just reflect everything, and I'll just say that
That is
since
that is up to you.
yes, I will do that.
Yes.
I think because you are playing around too much with the court.
No, no, my lord. Actually, we are also trying to save the money of the Union of India. my lord.
I know. But then your predecessors are there. How can you say that? Now, how can now the court has to pass order as per the submissions made at
Yes,
that time.
that is true. But this I'm not denying.
Now what to
This-
do?
This we approach the wrong from. This is our
And now,
fault.
and now 10 years have gone,
Yes, that is everything. This
more than 10
my lord,
years.
when deputy commissioner, the deputy collector is rejected on the delay, my lord, we have no any other. That is
What happened to the Supreme Court? You withdrew
My
the
lord,
case
the
before
Supreme
Supreme
Court,
Court?
when during the COVID time, it was approached, my lord. This is the wrong advice, my lord. This is, I don't, I
So
these big lawyers
so
are
you,
there.
you have got nowhere to run now.
Yes, my lord.
Supreme Court also, your case dismissed basically.
Not on the Mundran, my lord. Yes, that is true.
There's
My lord,
nothing.
everything is not, what I deny not, no, I am not denying. Everything
What
is
have
there.
you filed, madam?
If it is today, it's
For what?
In their,
Read petition.
There's nothing to file out here. There's nothing to file. Everything is there. There's nothing to file. Just you're giving them time to.
Actually, this I'm sending my lord is a central government council. I have to do a minimum instruction. My lord, this is my program. Otherwise, my lord, there's some adverse remark also come against me. My lord.
No, but then anyway, but please tell
And
your
yes,
client
yes, definitely.
that the petitioners are probably going to agree to set aside the award
Yes, ma'am.
and let a fresh award
Yes,
be
ma'am.
made as per the prevailing
Yes,
market.
ma'am, I also understand. I actually it is communicated.
Then now they will realize that
Yes,
how
ma'am.
much money they will
Yes.
get.
Only my lord, no decision order. Otherwise, my lord, this 19 may not come. I'll come to definite discussion. 19 January.
And I've given you, you just think about it in that line. Both of you talk to your client, both
Yes,
of
ma'am.
you,
Yes, ma'am.
as to whether a new assessment should be made as per, because you see, once the old assessment is set aside as per your prayer in
Yes,
the
ma'am. Yes,
pre-petition,
ma'am, I understand, ma'am.
once it is set aside, a fresh assessment automatically
Yes,
comes
ma'am,
into
this
play.
law speaks.
So there is, so you talk to your client and
Yes,
whether it's beneficial for you to agree to them, agree to them.
yes, ma'am. Yes,
Wait, wait. So all this thick thing will come down to just one page.
Excellent. We also want to conclude with this matter. Ma'am.
You talk to your client, I think they will withdraw this.
Yes, ma'am.
They should.
Yes, ma'am. Highly obliged, ma'am.
Otherwise, they'll have to pay through
Yes,
their
ma'am.
nose now.
I understand, ma'am.
Mr. S.K. Mehdi, then the CGC submits that he has received copy of the affidavit in opposition today. And he needs some time to go through the matter. He prays that the matter may be listed on 19/1/2023. Miss
2024, Your Lordship.
2024. Miss,
Viketsono,
which type?
Angami.
VK Chuno,
Yes, Your Lordship.
learned counsel for the respondent number 2.
Respondent number 2.
Respondent number 2 submits that he will obtain instructions as to whether the petitioner, whether the respondent number 2 would like to agree to the stand taken by the petitioners regarding setting aside the award made and making a fresh award for acquisition of land as per the prevailing market rate as on date. This is the matter on 19
January. But
Only that portion.
yes, ma'am, there's contempt is considered item 35. ma'am. The order to come along with this. That was the same.
Contempt petition, you write list the matter on 19.
My C is appearing file.
Miss Again appears for the respondent number. 105.
I'm fine for 3 minutes. Contempt.
Okay, write their name. Sir, you write their name. Miss.
1 2.
Miss. Correspondent number 1.
1 2 and 6.
1, 2, and 6.
You all take an informed decision.
Yes, Melody, I understand.
It is very easy to just, you see, dispose of this case.
Yes, Melody. Actually, last occasion I've gone for this, all this thing in Mizoram court in one arbitration case, Melody. This is regarding the new act, Melody, applicability of, I understand, but I'll inform the client.
Yes, inform the client.
Yes, Melody.
Especially if they carry on with this prayer.
Yes, ma'am.
It might be allowed.
Yes, madam.
So it will be like a case of operation successful, patient death.
That's true, madam. Highly appreciated.
For admission, item number.
Equal 4 and 5. 35. 20 meter. This is 37. Huh? No. The other one, my colleague is there. She is for 1, 2, and 6.
Hello, check. Hello, check. for admission from the supplementary portions, item number 38.
Where is the counsel for the petitioner? Tompok Kohima. Yes, Mr. Toshiko. Yeah, he was here. I saw it. Mr. Toshiko, come. You are the respondent in item 38, point number 6.
Yes, Lordship, I'm 36.
So you took the money
Lordship.
and
And
you have spent it.
Lordship.
Huh?
Yes, Lordship.
What are you doing? What work are you doing?
Lordship, I'm just a farmer, Lordship.
Farmer.
Lordship.
And,
So, Lordship,
is
on recent
mistakenly given to you.
mistakenly given me because
And you
Lordship,
mistakenly took it.
Lordship, since my land was also cut for construction of road.
Did you
In
get
the
any,
process,
did you get any
I did
compensation?
not. I did not get compensation. That is why I have read a complaint to the village council. The village council said that yes, you deserve to get a compensation, and accordingly, the village chairman has a.
Yes, who's appearing for the government?
So recent, as per direction of the Court Lordship, the district administration, they have taken steps, and on 9th, on 7th there was someone, and on 9th, on 9th they had a meeting, and the meeting minus was produced before the court, furnished before the court, and accordingly,
9th.
Lordship, and undertaking was also given by the respondent stating that I will give back the money.
Your name is Vepito Kefo? No. What is your name?
Lordship, the name is yes, Kefo. Wepute Kefo.
So how much money have you still got with you?
Lordship, I don't
9
have any
lakhs.
money as of now, Lordship. I've recovered only 2,40,000 out of the 11
So where
lakhs.
is that? Where is that 2,40,000?
That has been given to the government, and the state government, the state district mission has given to the petitioner.
So 9 lakhs is still to be paid.
Lordship. And accordingly, I have undertaken.
The petitioner was there in the field?
Meeting, Lordship.
No. What did they-
No, he was not. He was not summoned.
This is the petitioner.
Lordship, due to some technical listing, the list today, that's a jumble up of the list. That is why I think they oversee the list.
Okay.
That's especially the supplementary one. We didn't come to notice. I just learned that it was published. But since the matter was fixed, I bought my file. That's all. Even the government, I think, is not aware. And the petitioner was not
Okay,
aware.
list this matter on Thursday.
Lordship.
List this matter on Thursday.
Lordship. Yes, my lord.
The matter pertains to the respondent number 6 being given the compensation amount that was to be paid to the petitioner. That the paid to the petitioner. In terms of the meeting minutes dated 9 11/2023. The respondent number 6 was to make arrangements to pay back 9,08,605
Yeah, please.
out of the out of the rupees 11,18,605. That was to be given to the petitioner. Mr. Fosico Forte submits that rupees 2.2,40,000 has been paid to the DC's office, which has been paid to the petitioner. The question to be decided is whether the DC's office and the state government should be directed to pay the petitioner the amount that they have paid to the respondent number 6 and cover the same from the respondent number 6. Yes, what is this?
First, I'm for the state respondent, Lordship. We have received the instruction, Lordship.
Yes, that's fine.
So, Lordship,
What is the instruction?
the instruction is that it will be paid by the private respondent.
No. You have to pay. You paid and you take it from him. The private respondent will never pay. He doesn't have the money, he's a farmer. That is the arrangement between you two. You have made the mistake, you have to pay for the mistake.
Lordship, then I'll place that on.
You see,
There was someone by the administration, Lordship.
was the petitioner there in the meeting?
No, petitioner.
Not there. Then why should he's not bound by your decision?
Lordship, since the petitioner counsel is not there today.
That doesn't matter. He wants the money, that's all. Why should, I'm not passing an order against him, I'm passing it in his favor. How does it matter?
Lordship, in that way of the matter, since, let's come after the state matter, Lordship. I'll place that on the court.
You place what on the court?
Lordship, since I have received.
Okay, so no order be passed, huh?
Lordship. After the state.
Yes, you wait, both of you. And can you inform Mr. Pongana that we're taking up his case?
Lordship.
We'll call. After, yes. Because the mistake committed, but it appears that there is some foul play on the part of the respondent number 4 with the help of the respondent number 6. But that we cannot prove, and this is not the issue. So government, if they make a mistake, why should not they pay? If an individual makes a mistake, he has to pay. Why shouldn't the government be held responsible for the mistake they commit?
After the listed matter.
Yes, I'm just giving you my thoughts, so you can think about it also.
For orders, item number 20.
Your Lordship, I have served a notice to the respondent upon respondent number 10 on many occasions. And my last step has taken upon respondent number 10 is on 18 October 2000.
What is this case?
Land compensation.
So what is your case? Land compensation, I know. What about it? Are you going to give some money to land to somebody, or you want some money, or what? What is your case?
Yes, your Lordship, no proper compensation was given to the petitioner.
For why? Why should it be given to
For
you?
construction of 2 land.
2 lanes. It's on your land.
Yes.
Was your name part of the report? Beneficiary? In the award, was your name there? Was
A
our
small
name?
amount was given to the petitioner, but whereas for this we have written so many.
Small amount given for what purpose?
For land compensation.
Land.
Compensation.
Land compensation not given, I think. Damages only. You don't even know your case. Land compensation was not, you see, compensation was given to you for damages, not for the cost of the land. Now you want money for the cost of the land, basically.
Land compensation as well as the damage supposed to be given to the petitioner was not given proper amount.
Yes. What instruction will you receive? Your instruction is very clear from the affidavit of the government of India. I know. You don't have to fight. I think it's very clear that you are not, you have not made any award for giving compensation for land. Now, on what basis have you done that? You're supposed to give 300A, Article 300A requires that he should be compensated.
Your Lordship, may kindly allow me to serve upon the respondent number 10.
Who is respondent number 10?
Justice
Who is respondent number 10?
PIO of Office of the Commissioner.
The DC fake is here. Why do you want the PIO?
In the initial RTI application was given to the PIO.
Doesn't matter, doesn't matter. You don't, you're not understanding the nuances. Okay. When the deputy commissioner is here, why do you want the PIO of the deputy commissioner's office?
Your Honor, RTI should be addressed to the PIO of the Office of the Deputy Commissioner.
My God. Mr. Counsel is like this. Supposing you want something from the registrar of the High Court, Kohima bench, and you have made the registrar a party. Do you need to make the librarian also a party? Is it required? What is he going to do? What is the PIO going to do? When the registrar, when the DC is the boss of that entire thing, what are you going to, how is the PIO's presence going to help you?
We want RTI application to furnish the necessary relevant.
The DC will do it. The PIO is working for the DC. Then?
Yes, ma'am.
Then? When you, supposing it's like this, supposing you can get a document from the secretary of a department, why do you need to make the undersecretary a party? If you can get it from the secretary, why do you need out here? The DC is already here. Why do you want the PIO to be a party? It's not that important. Anyway, you want that.
Actually, the procedure we should have mentioned this PIO, not the DC.
Please read have you read the affidavit of the government of India? I was trying to dispose of the case. Okay, anyway. Okay, right. I mean, on the pair of the petitioner's counsel, Mr. What is your name? M. Mero. He is allowed to serve notice upon the respondent number 10 through dusty service and file affidavit of service thereafter. This is the matter after the application.
For orders from the supplementary cost list, item number 39.
Please, Your Lordship. It appears the department's counsel on whose behest the matter was fixed today is not present, Your Lordship.
And the service report on respondent number 2 is still awaited. Who is the respondent number 2?
Union of India, Your Lordship.
So where is the CDC can accept? Why is notice required to be issued? Yes. Yes. Allah. What is this case? What do you want?
Lordship, affidavit, this Parawise is under preparation, Lordship, and then Lordship, in 3 weeks time, Lordship.
Okay, Mr.
Vijumum.
The moment learned counsel for the state respondent is granted. How much time?
2 weeks time.
Under 3 weeks time to file affidavit in the position as otherwise comments have been received by him.
No, Lordship, it's
Oh.
under preparation, Lordship.
Otherwise
And
comments is under preparation.
Lordship, by the legal.
3 weeks
I'm told
time,
by
huh? This is the matter of the 3 weeks.
Bless you, Lordship.
For orders, item number 40 and 41.
May it please your Lordship.
What is your case here?
No, my lord, here, the petitioner had a lease agreement with the Department of Tourism for running the tourist lodge Dimapur.
Hmm.
The lease agreement was signed on 6th of September 2022
Hmm.
for a period of 5 years. Now, Lordship, according to the lease agreement, any party that desires to discontinue the agreement has to serve notice 2 months prior to such cancellation, Lordship. Here in this case, my lord will kindly appreciate that without issuing notice to the petitioner, the department has already leased out by entering into an agreement with the private respondent number 4, and only after the petitioner approached the Honorable Court, now they have served a notice to the petitioner, which is the 2 months period will expire on 16th of this month. So Lordship, interim protection is required.
How? They can serve that. There's no bar just because they're from.
No, they have served, but I have to vacate in a matter of few days, Lordship.
How much time do you want to vacate? We'll give you time.
Lordship.
We'll give you time to vacate. How much
No,
time do you
Lordship,
want to-
it is not my desire to vacate.
I know, but then you can't, you have to follow the agreement that you've executed.
No, Lordship, it is in violation of the agreement. In violation of the agreement prior to serving the notice to me, Lordship. They have already entered into an agreement with another party behind my back, Lordship. And on approaching this Honorable Court, they have served a notice to me, Lordship. So, Lordship, when the agreement itself is violated, and it is for a period of 5 years, Lordship, my Lord is aware that when there is an agreement, to terminate an agreement, there should be grounds. There's not even a single reason for termination of the agreement, Lordship.
No,
It's not that I have not performed.
They want to do business with somebody else. Where is the violation? Where does it say that reasons have to be given? Where does it say that? Now, suppose-
The agreement clause number 23.
Page?
My lord has the WPC number 234 or 266.
I've got 266.
266. The lordship in 266, the agreement is at page number 17, annexure 2.
Yes.
May I take your lordship to the clause number 23, page number 19. May I read your lordship?
Yes.
The lessee shall serve at least 2 months' notice in advance to the department in case of its desire to discontinue the lease agreement and vice versa. And my lord may kindly appreciate 25 also, clause number 25. In case of the failure to strictly adhere to any one of the terms and conditions by the lessee, as mentioned above, the state government shall be at its liberty to cancel the lease agreement after serving 1 month notice to the lessee. So, lordship, in any case, lordship, there has been no violation, and it's for a period of 5 years after making substantial investment.
That is 25. You have been given notice under 23.
Yes, lordship.
Maybe even after the proceedings of this case, but how does it matter? They've been given.
No, my lord will kindly appreciate this fact, that behind my back, without issuing notice to my client, the petitioner, they have already entered into an agreement with another party. Will that not amount to violation of the lease agreement?
They've asked you to vacate. But yeah,
At least a short interim protection may be given, lordship.
yes.
As far as the interim is concerned, that it is.
No, why are you terminating his lease.
Lordship, now the private respondent has come into the agreement. The state government as well as the private respondent, Lordship. So Lordship, now the agreement, which is at the agreement is at page 25. Lordship.
But when we have a subsisting agreement, can this agreement be valid agreement?
So Lordship, by letter dated 15 October 2023, Lordship, notice to vacate the restaurant petitioner was served on 15 October.
May I take your lordship to page number 21?
What is
Annexure
the
4.
cost of the estimate of the thing, of the agreement? What is the cost?
Lordship, security deposit of 2.50 lakhs.
2.50 lakhs. It's 17.
For how many years?
For 5 years. In the first page of the agreement itself.
Five-star hotel for 5 years. 2.50 lakhs of security deposit. And per month, how much? Nothing.
Lordship, the clause number 11, the caterer shall pay the power bill, that is power bill charges. Then,
And how much are you paying, petitioner?
38,303 rupees per month, your lordship.
But that has not been reflected in that.
That is at page number 20, your lordship, annexure 3, the permit. Besides this agreement, there is a permit, your lordship, page number 20, annexure 3. May I read, your lordship?
You filed your affidavit?
Lordship.
Mr.
Vijay
Momi, Learned Counsel for the State Respondent Service, that he will file his affidavit within 16 December is the last date. So you want to file it after, you tell me a date, within how many weeks?
Lordship, till that I haven't received any instruction. Lordship.
Then he cannot be left high and dry. Within 3 weeks.
Lordship.
Within 3 weeks. Here's the fact that the petitioner, where is the order? Order?
Lordship, it is at page number 53.
In view of the notice dated 15/10/2023, which requires the petitioner to vacate the premises in question by 15 December 2023. That status quo and the up to date shall be maintained till the next listing.
My lord.
Lordship, I'm for respondent 1, 2, and 3. There is a private respondent also.
Have you taken steps?
Yes, lordship. Through registered post.
Okay, right. As per office note dated 29/11/23, notice was issued upon the respondent number 4 on 29/11/23. However, there is no return of any card or answer notice from the respondent. Business matter. When is the vacation ending?
15 is the day the court reopens.
This is the matter of 15.
Lordship, in that case, the matter may come 17, Lordship.
17.
17 January. Oblige, your lordship.
For hearing, item number 25.
I think we had fixed some item. No? Some item. Which item? 38, are they ready? No, sir, they're not here. After some time. This item 25. Yes. Yes, sir. No. Okay, yes. Yes.
Lordship matter pertains to non-settlement of family pension.
Huh?
Non-settlement of family pension.
Family pension.
In respect of the petitioner, this is sought. Lordship, in case of short discharge, Lordship, the petitioner, this son was appointed in the year 1995.
Yes.
And after serving for 7 years, he expired in the year 2000.
No, tell me, he was appointed when?
On 17/5/1995.
As what?
As sectional officer.
Sectional officer.
Section officer.
Section officer.
Under RD department. Rural Development Department.
Okay, then.
The appointment was.
Was it a regular appointment?
Contract appointment.
Contract.
Against section post.
Okay. Then.
Then. Bay skill Lordship.
Then.
The Lordship. On her son was expired on 24 June 2003.
Huh?
24 to.
No. When did he retire? What happened? He didn't retire. He died in harness or what?
Yes.
Died in harness on?
24 to.
Was he regularized prior to his death? No.
Welcome to.
Oh, regularized after?
After. 24 to 2003.
Yeah, then.
The Lordship. By order dated 30/10/2003.
Yes.
The fix of the petitioner
With effect from?
With effect from 1/5/2000.
1/5/2000. Then.
Thereafter, Lordship, all the waivers, pension waivers, were forwarded to the Accounting General Office by the. However, Lordship, despite lapse of time, the implementation was not settled. Therefore, the petitioners are however, Lordship, even after lapse of 18 years, the authorities failed to consider case of the petitioner, Lordship. Therefore, the petitioner approached the Labour Court by filing the present petition. By filing an affidavit of opposition by Accountant General, statement has been made that the documents in respect of the petitioner's son are not available, traceable, and therefore written a letter to the department to furnish the pension papers so as to settle the pension. Now the dimension has been changed by filing the affidavit of opposition by the state respondent that the regularization of the petitioner deceased son was not by the government. The regularization was done by the director who has no authority. Now the question is now confined to the regularization. The only question to be decided is whether the director has the authority to regularize the service of the petitioner deceased son. Now, Lordship, the petitioner was appointed by the director in 1995. And regularization till 2010. All the regularization in all the departments has been done by the director. Now, by filing the affidavit of opposition, Lordship, The affidavit of association was filed by director and state government. Now the director himself has taken a contrary decision that the director has no authority to regularize the service of the petitioners to his son. The director himself has taken a contrary stand. Now my case is lordship. I've obtained some documents through RTA also. Many contract ad hoc would charge employees is regularized by the director, not only in respect of the RT department, but in respect of other department as well. Therefore, my submission lordship is the stand taken by the state authorities that the director has no authority to regularize service of the disease. My disease son is totally contrary to the reports.
That is okay.
Therefore, since my decision has been regularized by the director, the authorities are liable to pay the communication. Now, after lapse of 10 years, they are coming with a blame that no, regularization has been done by a person, by the authority, not vested with such power. Because such stand is acceptable at this stage. Worship,
Let
kindly-
us hear the other side.
Worship.
How do you prove that the director has the power to regulate? Just because
This is the respondent to show by reports that director is not winning authority was the director during that period that time. The conversation was made by the director and I speak of all the applicant countries. So later, responding authority satisfied this court, but director has no authority to the service of the ad hoc or the contract.
okay, let's ask them. Can I ask them?
Lordship,
Oh, it's not finished.
Lordship, as regards the conversation made by the director, I obtained some documents through RTI.
Yet giving me loose documents. You should file all this by way of affidavit.
Lordship, only after filing the affidavit.
That does not bar you from filing an additional affidavit.
Recently, this information was furnished on 31st October 2023. Worship me kindly turn to page 3.
Because they're surprising the other side also with this.
I've given a copy, Lordship.
When now they're surprising them at the last minute. That's what I'm saying. And this is a question of fact, it's not a question of law. You can surprise them with questions of law. If they don't know, that's their problem, that's ignorance. But questions of fact are something which might have to be verified.
This document is just to substitute my case, Lordship.
Correct.
Question of law.
But then
How
they
come
should
they
have
don't?
an opportunity to counter it, a question of fact. Question of law is a different issue.
Even in absence of this document, Lordship, it is a matter of fact that director has the authority. Page 3, Lordship. This is the regularization order issued by the director. This is in 2006. And now page 6, Lordship. This is also a regularization order issued by the director.
But then this, you see, there's no copy to the government. Anyway. So let us hear the other side. Now you've got some more documents.
Yes, Lordship.
You cannot give so much documents at the time of hearing, loose sheets. This is not done. It has to be part of the records. These are questions of fact.
Allowing me to file an affidavit.
No, that will
Because
allow.
this is
That's
the
not,
time stage.
that's not allowed. That's not correct. Yes, he says that the director has the power to do it.
Your Lordship, if he says that the director has the power to appoint, he should bring the document substantive.
No, no, okay, he's supposing he does not
And your
have.
Lordship,
In the same way, you should also substantiate your statement that the director does not have the power. How do you say that the director does not have the power?
Your Lordship, as you rightly said, since I brought some documents,
No,
Your
this
Lordship,
is
I may
the-
be allowed to counter, Your Lordship.
This is it. You see, madam,
Your Lordship.
you did not bring this up. I do not know why you're coming into issues that are already there. It's already part of the issue that has to be decided. Why bringing this up doesn't help anybody. Because the question still remains as to whether the director can regularize the person or not. What does your delegation of
Your Lordship,
power?
I have some OM with regard to contract appointment, Your Lordship.
Ah.
In that OM, it says that there has to be approval from the government, Your Lordship.
Okay, show
And
me
that
that.
was not.
Yes.
Your Lordship. I'll start from the first page, which is 4th August
Go.
2008, Your Lordship. And even then, there's this revised procedure for appointment in government. This is issued in 2001. That was before the regularization of the petitioner, Your Lordship.
Okay.
This is also relevant, Your Lordship.
He's taken. It's been hijacked by your adversary. But tell me one thing, is the director of government, is a government servant, no doubt, but director, can it be said to be a government? No, why? Huh?
Head of the department, HOD.
Is the who is director HOD? What about secretary? What is he?
Government officer.
Huh?
Secretary is the government.
What is joint secretary? What? Is government. From where do you say that he is the HOD and this is the government? From where do you say that? Is there any notification in support of your submission or it's what you? Huh? No.
The director cannot be termed as a government.
Huh?
Director cannot be termed as a government.
Why do you say that? Then if it cannot be termed as a government, then
There's no.
if the director cannot be termed as a government, then you're hitting your own case. You're cutting off the legs, your own legs.
So that is the fact also.
Then you've got no case then. Because your case is the director has regularized. And the government says that the director does not have the power because of the government. No, so director is not the government. But the director can do it. You said, so your case is that
Yes.
even though director is not the government, director can do it.
All along, director has been empowered to regularize the contracted services. During that period of time. Now
Since it was done earlier.
Now the law has been changed.
Yes,
And
yes,
it was-
madam.
Whenever there's financial implications are involved, Your Lordship,
Yes,
the
yes.
government, the approval of the government
Yes,
is required.
where?
Or Your Lordship, regarding that OM 2001, Your Lordship,
Para, clause,
second, page 94, your second page.
yes. Para, 6, 6(1), 6(x), 6(4), what?
Your Lordship,
On the top or bottom?
are you in page 94?
Yes,
Your
yes,
Lordship?
yes.
94. Okay, so, it starts in Romans I.
Ha.
It has to be borne in mind that contract appointments are meant to be only a temporary measure for a limited period till the vacancy is filled on regular basis through the NPSC. It is not meant to be permanent or long-term arrangement under any circumstances. No contract appointment shall be made for a period exceeding 1 year, Your Lordship. Accordingly, the appointment of the petitioner had been extended for 1 year, Your Lordship. And then, Your Lordship, any contract.
That has got no meaning. When you yourself violate, when you are
But
bound by.
it was the director, Your Lordship, without the approval, Your Lordship. And any contract appointment shall be made only to a vacant post where the recruitment is to be done through the NPSC. No contract appointment shall be made to posts falling outside the purview of the NPSC. For posts outside the purview of NPSC, the appointment shall be made in accordance with the rules laid down for such appointment. Before any contract appointment is made, the following actions shall be taken. The NPSC shall be formally consulted by the administrative department, giving reasons and justification why contract appointment is being resorted to. Prior clearance for making such contract appointments should be obtained in writing from the NPSC. After clearance is obtained, a requisition in the prescribed format shall be sent to the NPSC for filling up the vacancy. The fact that the requisition to the NPSC has not been.
This is relevant.
Your Lordship,
The issue is whether, this does not talk about regularization of a contract employee. Does it talk about regularization of a contract employee?
Your Lordship, this subsequent notifications, Your Lordship, which has been issued, has been based on this, Your Lordship. I'll show you, Your
Madam,
Lordship.
you're missing the point. The issue is whether the regularization of a contract employee can be done by a director. That is the issue.
Yes, Your Lordship, but this OM will show that the approval of the government is needed for regularization of the contract, Your Lordship.
Show me where. You have not been able to show. That's what, that 2001, nothing is stated.
2001, no, it's not.
Then 2008, where does it show?
2000, the 3 pages which I
Yes.
earlier, Your Lordship. 2000, I'll start with 2000. The first page, Your Lordship, 4th August 2008, Your Lordship. Regularization of contract ad hoc appointments against sanctioned posts. In partial modification of this department, OM even number data such and such, the governor of Nagaland is pleased to order the contract employees who have completed more than 3 years of continuous service of contract ad hoc will be eligible for regularization against sanctioned posts. The following terms and conditions will be applied for regularization of contract ad hoc employees. There should be a sanctioned post. The employee should fulfill the eligibility criteria for the post, including the requisite educational qualification. The OM shall not apply to posts where there are pending court cases. The OM shall not apply where the posts have already been requisitioned for filling up through the NPC. The suitability test should be conducted by the concerned department under the chairmanship of head of administrative department with representative from PNR department and ATI, Nagaland, Kohima. This is the.
Has this office memorandum been set aside by the court?
No, Your Lordship, still
Are you
existing,
sure?
Your Lord. Yes, Your Lordship.
It's still existing.
Yes, Your Lordship. Oh, Your Lordship, it has not been set aside, but but in one WPC, I don't remember, but this OM has been made unconstitutional, I think, but not set aside, I think. According to the opinion of the court, Your Lordship, in WPC. So this OM is just to show that the approval of the government is needed, Your Lordship, for any regularization, Your Lordship.
Where does it say government? It does not say government.
The administrative head would be the government, Your Lordship.
Where does it say administrative head?
Here in para 2, Your Lordship. The suitability test should. And para 3 is also.
Head of administrative department.
Yes, and para 3 is also important, Your
So head of the administrative department will be who?
The government, Your Lordship, the commissioner, and the affidavit.
But then
also-
this is of 2008. He was regularized in 2004, 3. Then will it have retrospective effect? Supposing government issues a notification now, can we automatically apply it to a period, say 1975 or something?
But even then, when, Your Lordship, when there is financial implication, Your Lordship, the approval of the
Show
government
me,
is
show
needed, Your
me,
Lordship.
show me.
Your Lordship,
It will be there, madam. You just have to burn
yes,
some
it's there,
midnight
it's
oil,
there,
that's
Your
all.
Lordship. It's just that it's just the top of my head right now. I am not able to find out, but it's in
If it's in
rules
the
of,
top of your
rules,
head.
rules of executive business, Your Lordship, it's there. It's just that I'm not able to find it right now. I've come across, Your Lordship.
If it's in the top of your head, it's nowhere around my head at least. Unless you show me where it is. Only one, only for yourself. Okay, please read. Since you've got only one copy.
It's dated 18 March 2007. Obtaining
That
of
madam,
the,
2007,
Your Lordship, but
2003, prior to 2003, at least 2000.
but it's in the rules of executive business as well, Your Lordship.
Show me the rules of executive business. Compare and contrast. The nails, we are bringing out the nails now. You just have to now close the coffin with the nails. And then, so the petitioner is worried now. But if you can't close the coffin, then the ghost will come out.
Your Lordship, if I may, this matter may kindly be listed on Thursday, Your Lordship. I'll bring the brief. Your
Okay,
Lordship.
correct. The only issue to be decided here is whether the director would have regularized the service of the petitioner's husband on 30/10 with son on 30/10/2003 without obtaining the approval of the government. That's all. Yes, you're for whom?
Lordship, I'm for the AG, respondent number 4, the
What
accountant
is
general.
your take on this?
Lordship, our stand is very limited. I'm relying on my paragraph 5 and 6, that's all, Lordship. So the family pension in respect of the petitioner, there is no record in the office of the accountant general. So we have written to the state to furnish us the entire document so that we can process. That's all, Lordship.
No, but what about the law?
Well, as far as the law is concerned,
What the-
Lordship,
is the
there is a
director-
dispute between the petitioner and the state respondents.
So you're behaving like an ostrich now. Huh? Let them fight. I'm not seeing anything. Okay. So what to do?
But Lordship, we also had one apprehension. Within the period of 2003 to 2005, there were lots of fraud pension cases. And that is why we could not take chance. We referred back to the state to give us the entire document.
No, you see, the only thing is whether, you see, the director is basically a director. He has to have government approval. That though I'm pretty sure about it. So let her bring the documents. If so you'll have to also do some research work as to whether a director on his own can regularize the services when he is not the authority who's paying for it. Finance department pays, not him. And service filling up of posts has to, the permission has to be given by the government, not the director. I don't think so.
Well, also, case pertains to 1995 to 2003. The issue is whether power during that period.
Correct. If he has been empowered, then okay. So if you see that, if you have some document showing that the director is empowered to do it, then okay. So you bring to us on Thursday. Will you be ready? Yeah.
Your Lordship, I think I'll need more time, Your Lordship. So maybe next week,
Huh?
next week.
No, only that document with regard to, what have you said in the document?
At the affidavit, in the affidavit. Just saying that since the approval was not taken, the regularization of the petitioner is irregular and therefore he's not eligible for family.
That
The
is correct.
petitioner is
That
not
is correct.
eligible for pension,
Actually,
family
but
pension.
I just wanted to bring the document. That is correct. Cannot be
And-
done without the approval of the government. Regularization, because it touches upon the finances of the state. So the state, the government will have to give approval, but there is that, so the power of the director, where is the power of the director to regularize a person? Just because he has done it 20,000 times may imply that he has the power, but then when the question is raised as to whether he can do it, then we have to go into that question.
Issue has been used, with petition report. Any cases, Lordship,
And-
where the regularization, customers regularization has been done by the HOD, and this whether court issue correction to the patient.
Where is that?
There's, I have to check, oral past petition report, Lordship.
Let's see.
Regularization has been done by the HOD, Lordship.
Regularization has been done by the HOD. Who is the HOD?
Engineer in chief. Engineer in chief and the
He also doesn't have the power. You bring the document. Okay. So you see what you can see is that the delegation of powers given to the director in that period, 2003, 2004. 2003 was the order. So 2003, what was the power of the deputy director delegated by the government? Okay. So that will clarify. There's always that delegation might have been made in 2001, might have been made in 1995. It will carry on. It's not that every day they make it or every year they make it. It's made maybe 10 years, 15 years or whatever.
Lordship, for academic purpose, as far as the practice during the 70s are concerned, or even in the 80s also, with or without delegation of power, even the junior engineers in SDOs, they used to appoint. So I do not know how the petitioner will be able to prove that, or the state has documents to prove that.
No, but one thing
However,
is clear,
yes.
because the government being the custodian of the,
Yes,
the
Lordship.
financial affairs of the state,
My lord,
the government approval is needed.
Lordship.
So even if they don't bring documents, if either of you cannot bring documents, we'll have to go by that philosophy. Otherwise, each director will regularize whoever he wants. Then what happens?
is regularly services are like service regularized by the director. If this people find that no, like there is no authority, this is power, the director is to respond to regularize like the service of
No, depending if you have got the requisite qualification.
Initial appointment
You-
was also irregular.
It's not contractual.
I was submitted against section post.
Maybe, you see, maybe against action post, but the issue is that even the regularization after the death is because you cannot even apply Uma Devi for the simple reason that you did not even complete 10 years.
That place to check. That is how the British worship,
No, so the authority accepted. Now which authority is that? Thereafter only a corrigendum was issued by the Office of the Engineering. We do not know who has regularized his service. Okay. Anyway, right, you get the document. I can dispose of, but so let it be clear. Let this issue be settled once and for all. Can you get the document?
I'm trying to get it by Friday.
This is the matter.
Friday.
No, this is the matter of Thursday.
Thursday, I think it will be difficult.
Okay, Friday.
Friday.
Friday. This is the matter of Friday. Sorry.
Lordship, Lordship.
Yes.
Lordship. My apologies, Your Lordship, not knowing that it will take so much time to. We have not made a mention of the item number 42. I was expecting that there will be sufficient time to hear this matter. But since an extensive
no
hearing
time.
is required for this
Yes, yes.
matter,
On the prayer of the Petitions Council, this is the matter after a week.
after the vacation.
After the
Your
vacation.
Lordship.
After the vacation. Yes. Next.
Oblige, Your Lordship.
And we have got one matter, I think.
Item 43, Lordship.
Yes.
Lordship, this matter will be listed next week
Okay.
on Tuesday, Lordship.
43, this is the matter on Tuesday. Then we have got that one matter is still pending. That pending matter 38 or 39. Any other matter pending? Okay. Okay. Continue.
For hearing item number 28.
28.
Yes, my lord. I've been appointed in the year 1992 and I've been serving for more than 30 years, Lord. And as per the memorandum 17/3/15, I'm seeking for regularization of my service.
What does the office memorandum require you to have?
Lordship, I have been serving more than 30 years.
No, that's
Yes,
okay.
Lordship.
30 years. What does the memorandum say?
If Lordship will come to
Yes, page
page
16.
number 17,
Ah.
Lordship, Roman number 2. In respect of those work charge and casual employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/15, their cases for regularization will be taken up subsequently in 2 pages studies on 1st July and 1st January every year. The procedures in terms and conditions will be the same as laid down in this one.
Okay. So.
And Lordship, there is also.
No, please see. So you have got, you are getting scale pay.
Lordship.
And you have completed 30 years.
Lordship.
As on 1/1/2015.
Lordship.
Or after 1/1/2015.
Lordship, I was appointed in 1992. Now I have completed 30 years. I'm still continuous in service.
Okay. So you still, how old are you? You joined when? Which year did you join?
1992, Lordship, April.
1992 April,
Lordship,
and they're still working
Lordship,
in 2023.
Lordship.
That means
There is also
you have
forwarding.
been working for now. When are you going to become 60 years?
1 or 2 years, Lordship.
1 or 2 years? Are you sure?
Lordship, there's also a forwarding letter from the executive engineer to the engineer in chief.
You are 56 years of age. Hmm? In 2023. That means next year you'll be 57.
Lordship.
Now, if in 2023 you were 57 years,
Lordship.
that means in 2003 you were 37. In 1983 you were 17. Is it?
Lordship, if please come to 15, page number 15, Lordship, the ID card, Lordship.
1992, no? Okay, 1992 you were.
Lordship.
Yes, madam.
Lordship, it is not denied that he has 30 years of service. So this qualifies him for regularization.
Correct.
So your Lordship, the engineering chief has written to the Longland division where he is attached to submit all his necessary documents, that is his service book and his first appointment orders. Those documents are awaited, your Lordship. Once it's received, his case will be processed for regularization.
But they will take time.
Yes, your Lordship, that
Why?
will take time.
Why? Why should it take time?
Your Lordship, the documents are awaited from the.
Madam, this is January 2023 when the issue was asked, when the documents were called.
Yes, your
We'll
Lordship.
ask this executive engineer to come to this court with the records. Let him appear before us. This is there's no point disposing of your petition. I can dispose of if you want. I can dispose of.
Lordship.
The only thing is that they will not do it, and then they will say that documents have not arrived from this executive. This is 20, Madam, 20 on 20 January, 20th January 23.
Yes, your Lordship.
Documents were called for. Now more than 10 months have gone. 10 and a half months have gone.
Then your Lordship, if I may be given some time to get the instruction, if they have received the
No,
document.
no instructions. What? Acha,
If the-
we'll get it. You ask them now. Or you ask them now. By phone. Can you get it?
Lordship, then just give me 5 minutes.
Yes, yes. Because I can dispose it off, but only problem is that if they take the excuse that the documents are not arrived. Now also they have not, I think it should have arrived. Otherwise, we'll give them a short date that you do it complete the whole process within 1 month. And then you can file contempt. That'll be easier.
Lordship.
I think that'll be better. Otherwise, you obtain instruction test.
For hearing, item number 29.
Both 28 and 29 are in the longest.
Same.
Yes.
Suggesting.
Same departments.
Yes, sir.
For hearing, item number 30 to 34.
Lordship, I beg to mention supplementary item number 38, Lordship.
Yes.
If this matter can come up on Thursday, Lordship.
Everything on Thursday?
Thursday.
Okay, at 38 on the prayer of the parties list the matter. You're for?
I'm for the petitioner, Lordship.
Yes, but you're not ready for 38? You're ready? They're ready. What remains? Nothing. You wait. We'll wait. It won't take long.
I'm not giving one, Lordship, since I'm having a headache.
No, okay, what is their submission? We'll just take up your case.
Okay, Lordship.
Just a minute, we'll just take up his case.
Lordship.
You have shown it. Yes, so your case is that your money was gone, has been given to respondent number 6.
Lordship,
Correct.
without my knowledge.
Without your knowledge. Now, your case is that it has been given by mistake to the respondent number 6.
Lordship.
And now you have had a meeting with the respondent number 6,
Lordship.
and whereby respondent number 6 will repay the amount.
Lordship.
Correct.
Lordship.
That's all. What
Lordship.
else?
Lordship, may I kindly come to the page 1, Lordship, of the instruction that.
Page 1. Page 1, yes.
Lordship, this is the action taken report.
Yes.
With regard to the statement.
Yes.
And Lordship, may kindly come to second page, Lordship.
Yes.
Second page, it's a meeting minute.
Yes.
Meeting minute, and then in attendance, the meeting was chaired by EAC PEG.
Yes.
And also it was attended by VCC, Losami, and secondly, the private respondent. Private respondent and the three go with the mercy who issued the no objection certificate, to whom it may concern, certified, and three will be the, who is the petitioner.
Petitioner was not there in the meeting.
Lordship, here petitioner name is reflected. Sri Webide.
Oh, serial number?
The meeting was chaired by Sri so and so ESC PEC and had the attendance of Sri Z. Mercury, BCC Losani, Sri Webide lawyer, respondent number 6, Sri Gowete Lasu, who issued the who certified on behalf of the village council chairman, and Sri Webide, the petitioner.
Sri Webide, where's Sri Webide?
Webide.
Webide Kathe, Webide Kathe, yeah, Webide Kathe.
Webide, the petitioner, the present petitioner.
I'm asking the petitioner, what's your name?
Oh, Webide, Lordship.
Webide.
Webide Kathe.
Lordship.
No, but then in your cost title, it's only Webide, there's no Kathe.
It's Webide only.
Is your name here? Did you attend the meeting?
Yeah, page 2.
No, you come to the persons who attended the meeting. Is his signature here?
No, in the signature is not there.
Then?
In the attendance.
Then
However, Lordship, in the meeting, meeting minutes, here the name of the petitioner is reflected. And moreover, Lordship.
Where in the meeting minutes?
Page 2.
Page 2, which page 2? I've got page 3. There's no, which page 2? Show me. That is not the meeting minutes.
This is the meeting minutes pertaining to issue of wrong payment of damage compensation under Kohima Jasami Ulan.
How does it start?
Action taken report.
Just show him this page. His page 2 and my page 2 are completely different. You give me that also. Give me that also. You give me the one you've taken also.
The one which I gave you, my lord, this is 17 November 2023. And this is the latest one, Lord. For December 2023, Lord.
Yes.
So the first page is a covering letter, action taking report in the incident case, Lordship. And Lordship may kindly come to page 2, Lordship. Page 2 of the letter dated 4 December 2023.
Yes.
And here the name, may I read, Lordship?
Yeah.
Meeting minute pertaining to issue of wrong payment of damage compensation under Kohima Jasami Pulan Law. The meeting was chaired by Sri C. So and so EAC PEC and had the attendance of Sri Tache Mekusi, who is the present BCC Losami, and the second is the Sri Wepite lawyer, who is respondent number 6, and Sri Gowete Lasu, who is the one who have certified that the petitioner's name and Wepite lawyer are one and same, Lordship. And lastly, and Sri Wepite, the petitioner's name is there.
No, but then this is not borne out by the Wepite. Okay, so he was there.
And Lordship, may kindly come to the last paragraph, Lordship.
Huh.
Now, therefore, taking into account the state of living condition of respondent number 6, who is the sole breadwinner of the family with limited resources at his disposal, has agreed to repay. Now he has agreed to repay the remaining amount of rupees 9,08,605, not in cash, not in cash, but through means of forfeiting his possessions in the form of second-hand Tata Sumo and 2 vast plots of land adjacent to 2 land roads, and the respondent also agreed to forfeit whatever amount that he received from lateral damage of his properties located at Losape village. In this regard, it may be mentioned that the council chairman Losami have agreed to physically verify the plots and hand it over to the petitioner if the latter agrees to the agreement also. So here the petitioner, the petitioner who was also in the attendance in the meeting, minute lordship, and then it has been agreed by the respondent number 6 to repay the same amount lordship. Not in cash, but in kind.
Lordship, regarding the letter, I received it just now, and I have my client, he hasn't contacted me yet.
So just contact him and we'll adjourn the matter on Thursday.
No.
One thing I want to know, did you attend the meeting?
Lordship, that too I have to ask my client.
Yes, you ask him whether he attended the meeting and whether this is his signature.
Lordship.
Let's see that, huh? Correct. On the prayer of the parties, this is the matter on Thursday.
For hearing item number 30 to 34.
Any other matter pending, Bhagwat? Yes. Will you take long, Mr.
Short matter, my lord.
Huh? Short matter. What is the matter about this?
My lords, I am telling you the suspension order. Suspension of service.
Suspended when?
Only question of law.
Suspended when?
Suspended on 28/12/2019.
28th of 2019.
Yes, now it's going to be 4 years.
The department proceeding initiated.
Nothing.
Huh?
They have issued a memorandum, but till today nothing happened. Now it's going to be 4 years. On 28th of this month, it will be 4 years. Till now, nothing happened. And
A
for that,
memorandum issued when?
memorandum was issued on 17 March 2020. So even after issuing this, nothing happened for 4 years, and so therefore, suspension, prolonged suspension of service is bad in law. I have some only question of law.
Anyway, what is the issue? Where is the memo submitted to you? Let us see. Page.
My lord, before I just give a nutshell, just briefly, I'll explain the format. These are
No, just show me the memo or memorandum. That will clear up everything.
this is Vision 1999. Vision 99.
Yes.
Page 15.
15.
Page 15.
15.
Yes. This was issued on 17 March 2020 by the Additional Director General for Prison.
Which no government servant shall bring or attempt to bring any. Where is the imputation of charge? Administrative. The night shift duty has been
Page 16.
Acha, one person escaped.
Yes, madam. Jail escape case, madam. The petitioners are jail warders, constables.
So he did not attend, he did not go for duty or? He did not go for duty or what?
Yes, that is the allegation.
But if he did not go for duty, then the person who he was to replace, that person left also or what? What? Huh?
There are not only me, there are four, maybe around 8 people were on duty in jail
Ah.
normally. That day, the allegation was that when I was in the toilet, escapee ran away from the jail.
Okay.
So after that, the jail authority ordered that we must go for operation, search operation. And subsequently, the escapee was arrested again from a far beach, was brought back to jail. Now, after that, the allegation was that when this fellow, the escapee was brought to jail, he was beaten and subsequently he died.
Oh.
That is the allegation. That's why I thought.
So but then this memo doesn't say that.
Nothing.
Huh?
Article 2, worship C, Article 2. Article 1 and 2 are the charges against me.
Where is Article 1?
Page 60.
This is Annexure 1.
E.
Article 1. Yes.
Correct. This is annexure to M memorandum.
Annexure 1, yes.
Yes. Annexure 1 to memorandum. Article 1,
Acha.
Article 2.
Beating up inmate. When did you? So.
Satya Odeo was a UTP, but he was not there. He was not beaten. The allegation was that this fellow Satya Odeo ran away. Then another fellow who tried to run away was beaten and subsequently he died. That's the allegation.
Yes, please appear it.
So now.
So basically, you're saying that because the DP has not started,
No, nothing.
you should be reinstated.
Yes, because prolonged suspension.
Is there any criminal case filed against
Very
you?
much. Criminal case is pending. Trial is going on.
You're still in jail.
Yes, still. No, we are on bail. So the only limited question here is whether suspension can indefinitely continue.
But you're in jail. But there's a criminal case against you.
Very much. There are cases, similar cases where though the criminal cases are pending against the petitioner, there has been petitioner has been placed indefinitely under suspension, which is not in the interest of the government also as well as the petitioner also. That is why.
What about keeping in view the severity of the charge?
That will be considered by the trial court because I have to come up clean on the trial. And that.
So what are the citations?
On 2 counts, I have 2 counts. One is first thing is a prolonged suspension is bad. That is citation. I will show. First of all, I show one judgment of all judgment.
Prolonged suspension is bad.
Yes.
Then.
GLT. JLR Volume 1, 1990 by Division Bench.
And what? How does it start? Which year?
JLR Volume 1, 1990.
Page?
27. It's a short judgment. 276.
Yes. Yes. Unless you are giving me a copy, I have to listen to you. No choice. I'm totally in your hands. You did not give a list of books. You've given?
Yes,
It's there. It's not there.
We have given.
Okay. Then carry on.
Just this is Division Bench judgment.
Yes.
Just this is Justice J.N. and this just short. The petitioner was a lecturer in Madhya.
No, let's go to the yes.
Paragraph 5.
Yes.
Without entering into that controversy at this stage, we do not think that prolonged suspension for more than 3 years of the petitioner from service without any further action inviting, having been taken in the matter was neither proper nor justified. Suspension from service is a very serious matter and should be for as minimum period as may only be necessary. A prolonged suspension without any justifiable cause is not only wastage of human resources, but also of material resources of the organization which has to pay the subsistence allowance, etc. without any return. We find absolutely no reason to continue the suspension of the We therefore revoke the suspension order of the petitioner from service with immediate effect, but make it clear that it shall be open to the respondents to pursue disciplinary action against the petitioner as may be necessary. Also, the matter related to the alleged irregular appointment of the petitioner. This is the judgment. Now, a similar judgment from the Allahabad Court.
You give all the judgments together.
This is also that also 3 years. In my case, 4 years now. In this case, also 3 years now. The relevant paragraph I just read.
Yes.
Paragraph 7.
Yes.
Paragraph 7, third paragraph.
Yes.
Third paragraph. Secondly, from the report, it is evident that the order of suspension was passed on 3/11/2004, and after almost 2 years and 10 months, on 10/9/2007, the assistant basic education officicer issued charge sheet to the petitioner, which has been replied by the petitioner on 11/9/2007, and thereafter, almost 11 months have passed since then. But the inquiry has not been completed so far. The question to be answered would be whether such prolonged suspension is justified. The answer is no. The prolonged suspension of the petitioner is clearly unjust and unwarranted. The question deals with the prolonged agony and mental torture of a suspended employee where inquiry either has not commenced or proceed with snail speed. Though suspension in a contemplative or pending
Okay, and
inquiry.
any other thing besides this?
This is on prolonged suspension matter. This is, my lord, on the prolonged suspension, this is SEC 2018, volume 7. Volume 7.
Page?
7, volume 17, man. Volume 17. Page 677.
Para?
The relevant is paragraph 24, 5, and 27 on prolonged suspension.
Yes. Yes.
The principal label is suspension. 24. The first respondent was placed under deemed suspension under administration of all India services rule, being in custody for a period of more than 24 hours, arising out of criminal case. Periodic review were conducted for his continuance under suspension. The recommendation of the review committee did not favor his reinstatement, which he is still under suspension. Mr. P. Chidambaram, then senior counsel, appearing for the first respondent, clearly submitted that we can proceed on the basis of that criminal trial pending. There cannot be any dispute regarding the power of the decision or jurisdiction of the state government for continuing the first respondent on the suspension. Right. There is no doubt that the allegation made against the first respondent are serious in nature. However, the important sentence. However, the point is whether the continuous suspension of the first respondent for a prolonged period is justified. 25. First respondent.
Okay, I have it. Then next.
This is on prolonged suspension matter.
Then.
Now, my lord, another question is, as Lordship is aware, in the Ajay Kumar's case, the Supreme Court has held that there should be a periodical review of suspension. Matter. This is SEC 2015, volume 7.
That is prior to the charge sheet or the memo of charge being filed. And only, and then after that, maybe once they need to do it, that's all.
Yes. If
Ah,
charge sheet is filed,
that periodical review after that is not necessary.
if according to
So outage
judgment,
has been filed. That you have missed the bus now.
paragraph 21,
Ah,
that if I may be allowed to read out.
yes,
May I read it?
yes, yes.
Paragraph 21. We therefore direct that the currency of a suspension order
Shall not continue.
should not extend beyond 3 months if within this period the memorandum of charges or charge sheet is not served on the delinquent officer or employee. Then relevant part for in my case is this. If the memorandum of charges or charge sheet is served, this is my case. A reason order must be passed for the extension of the suspension. In this case, in my case, no review has been, no reason order has been passed. As in the case in hand, the government is free to transfer.
No, we've got that.
Yes. Now, based on this, my lord, this is for the division bench of Gauhati High Court, GLT, volume 19, GLT 2009, volume 5.
You have volume 5, GLT.
GLT 2019, volume 5. Page 44. Page 444.
Para.
Paragraph will be 11 to 15.
Yes.
In view of the submission of the land council for the appellant, that the decision is not applicable to servant whose condition of service.
No, go to the relevant portion. No, you read the entire thing too long.
Okay. Paragraph 40.
Yes.
In respect of the submission of the land council for the appellants, this appeal was filed by the Nagaland state government.
I know, against my judgment.
Lordship also has passed another judgment based on Ajay Kumar's case in Assam. Yes, madam. Lordship has passed one judgment in respect of Assam case. Similar, based on this similar point. Based on these two judgments, based on Ajay Kumar and based on this different bench. May I read paragraph 40?
Yes, basically of that.
Yes.
Yes.
So
that's all.
In this case, even after 90 days, charge sheet was not filed. So on that count.
No, that is gone. That is
Yes.
that is water under the bridge.
Yes.
That is gone.
So these are basically the two law. One is prolonged suspension is not legal. It's not justified. So for that, now in my case, this jail warden has been under suspension for almost 4 years now, and no progress in this request.
So inquiry officer appointed or not?
Appointed.
Presenting officer appointed?
Yes. Appointed.
But no evidence.
Nothing.
Yes.
Almost 4 years now.
Yes.
Charge sheet in criminal case was filed on 23/3/20.
Charge sheet filed on
23/3/2020.
2020. Yes.
Okay. That's going on now.
So what is the status of the trial?
Last, when I contact, then was last stage of evidence.
Evidence is not the last thing. Evidence, how many?
Lordship, I'm talking about the last stage of the evidence, last part of the evidence.
No, but how many prosecution witnesses are there?
Lordship, I do not know
You
that.
see,
Lordship.
one thing I want to know, how many prosecution witnesses are there? Out of that, how many of them have been examined?
That detail I do not have, but they say
Because
that.
that would have a bearing in this case. Then, because after prosecution evidence, maybe defense written evidence,
Yes.
and then 313, then judgment, that's all. So I want to know how many prosecution witnesses are there and how many has been examined. You don't know.
That I don't know, but Lordship, since the issue is only prolonging of the suspension and the periodical review, Lordship, that I'll
No,
try
no,
to.
no, that review, that's water under the bridge now. That's water under the bridge. I'm more interested on whether the criminal trial will end, how fast the criminal trial will end. You see, because criminal trial can be the basis for inflicting a punishment on the delinquent officer. If he is found guilty in the criminal trial, on that basis he can be imposed a sentence. Okay. It's only when he is found innocent, acquitted, that maybe you are going to start a DP. Because earlier the law was that when the criminal trial and a DP can be proceeded with, it is safer to have the criminal trial first. It's better to have the criminal trial first, then only the DP should start. So in that context, what you are doing might be correct. But then if the criminal trial is going to take another 5 years, or another 3 years, or another 2 years, we have to see that.
That long, I'm sure that one you won't go that long. Lordship.
No, but already 4 years have gone.
But Lordship, one thing is we have to appreciate the COVID 2020, 2021. So that is there. Though government, I'm not saying that government is always very fast, but that's that we have to appreciate.
What we can do is, Mr. Zo, we can let him, I want to know the status of the criminal case. If the status of the criminal case is at the fag end, then that criminal case can be disposed, once it's disposed of, then I might not want to interfere. So that can decide the issue. So we can list it tomorrow or day after. We find out. Only with regard to the status of the case. I want to know how many prosecution witnesses are there, how many have been examined. That's all.
My colleague, that we go out of 29 witnesses, PWs, where I get to certify. Out of 29 witnesses, 20 have been examined recently, and the case is fixed January for next examination. So, there are a little more than a year. I put my colleagues, 20 examined, so 9 remain after that defense. And this case is fixed on January, 30 January next year. So it is
Another thing, the article of charge that you have framed against him doesn't mention that he killed, he just beat up, that's all.
No,
The death was the cause of the, nothing is there. You have only charged with beating him.
Lordship, there are 5 more here in the case. There are 5 of them.
They are all under suspension.
Yes. Now I think he was in the charge sheet in the. I think he was the charge sheet.
Oh, there are a number of petitioners.
Yes.
Altogether 5 separate petitions.
The same incident.
Same incident, jail warders, all kinds. The allegation was that, as I have mentioned, the SKP ran
So the articles of charge is same. All of them beat up also.
Yes, there shall be no murder.
Now, what is the criminal case number? What is the police station case number? What is the case number?
Case number is section 448.
No, police station. Which police station case number is it?
Walk up, PS.
Walk up PS case number?
Page, Lordship, repetition, page 4, paragraph 3. Walker, PS case number 50 of 2019.
Page?
Page
WPC 99.
My lord,
Page 4,
page 4,
Para?
paragraph 3. The
No.
middle part,
para, page 4, I've got para
Paragraph
9,
three.
10, 11.
paragraph 3.
Paragraph 3 will be in page 2.
Repetition,
Acha, this is the. Acha,
I'm
this is
so
the.
sorry.
No, no, no.
Page
Okay.
4, paragraph 3, my lord.
Paragraph 3, yes. Okay. Yes.
Yes. There's no moderate charge.
Some of, like in case of 102, the WPC 102, that is mentioned. That is mentioned.
Different. Charge is different in 103. Charge is different in WPC 103. 102 also is different. But all are different. So it will take some time.
Actually, the sequence was presented.
Huh?
Of the 5, the lightest is presented, I think. Where did-
Okay, okay.
Anyway, it's all right.
Or as a first item, that is the first item. Now, even if Lordship can read the other charges also. Article.
I want to read, I have to read. I have to read.
Only-
Actually.
Only Article 1, 2, all, and more or less same.
I know your submission will be the same. Only I'll have to see the charges.
Even charge, article of charge are more or less same.
What we'll do is you find out with regard to the status of the case.
Okay.
Okay, and how many witnesses, how many have been examined? Then we'll see. Thursday, there's no time.
I'm out of station.
Oh.
I'm going to conduct one criminal case in outlying district.
Okay, okay. Because it takes some time. I want, then we list it next week.
This week, Lordship, I have a fixed matter Tuesday also, Thursday
My
also.
lord, if it is not possible, then next year. Because we have to fix, even tomorrow we have one criminal case here.
Because I've got these 2 cases to dispose of now. They're waiting. So this will take time.
My lord.
Because I wanted that status report with regard to the criminal case. Right on the prayer, the parties list the matter in the after the vacation.
My lord.
I could have disposed, but no time.
Yes, yes.
For hearing,
For this week and next week, we have only 6 matters. My lord.
for hearing, item number 28.
And 29. Yes.
Yes, Your Lordship, the department has received the documents
very
and
good.
it is
Both.
under process already.
Oh, very good. So that's good. So right, heard Mr.
PN form, Lordship.
Learned counsel for the petitioner, also heard Miss AIME, learned counsel for the state respondent. Good stuff. The petitioner's case is that he has completed 30 years of service as a work charge employee in the Department of PWD bracket R and B bracket close, comma, long length division and being paid scale of pay. Good stuff. The petitioner's prayer is for a direction to be issued to the respondents to regularize his service as per the scheme provided in the government OM dated 17/3/2015, comma, as he has all the requisite requirements, as he has all the eligibility criteria required for regularization in terms of the OM dated 17/3/2015. Miss Miss AIME, Miss AIME, no, AIME, Miss AIME, Leonard GA submits that the documents that the petitioner's records had been called for by the Engineer-in-Chief NPWD, Nagaland, from the Office of the Executive Engineer, PWD, bracket RNB, Longlang Division, and the same has already been received by the Office of the Engineer-in-Chief, NPWD. So she submits that the uh, the respondents are processing the petitioner's case for regularization in terms of the OM dated 17/3/2015. So subnext para. In view of the submissions made by the council for the parties, the respondents are directed to complete the process for regularization of the petitioner's service within a period of
6 months. Because your lordship regularization process is a lengthy process. It will have to go to PNR first for clearance.
yes.
Then
Within I said 5 months yesterday. Within a period of 5 months from the date of receipt of a copy of this order, in terms of the OM dated 17/3/2015, the writ petition is accordingly disposed of. Then in the next case,
Item number 28.
20, 29.
your lordship, same order may be passed.
But we'd have to see out here.
Here
Same.
was first appointed as SS labor.
No, we just said 30 years of service, the same thing, same, no, nothing is changed. I'm not mentioning all that, the records are there, no? So same order.
Much obliged.
That's why you want some orders. I could have done, I thought this would take long actually, I could have done ages back. But then, no problem. I see it's happy.
Ask about that.